Yes.
Lord, I like to mention for listing of one urgent matter.
When?
On the next Tuesday, you.
Tuesday.
My lord.
Motion matter.
No, my lord, orders matters.
On 25th. On 25th, Wednesday.
But then. Master.
Maybe on 16 lordship, I have made a mention for listing of CRB IO lordship on behalf of state of Assam lordship. But that was lordship had allowed it for today lordship. But due to inadvertent mistake in mention memo, I have written that on 17/9 lordship. That's why lordship it was not listed today lordship. But today is a date for execution of order lordship. The property of attachment of the deputy commissioner lordship. So, lordship, may I allow for at least the unlisted motion, lordship?
When? Today?
Today, lordship. It has
Okay.
added.
Okay, we'll try.
Online.
May I please, your lordship? I beg
Yes.
to mention for listing and CRPI on Tuesday.
Next Tuesday.
Yes. Obliged.
With your lordship permission, I beg to beg for listing of a matter, MSc appeal,
When?
2016 matter on Wednesday, 25th,
For hearing,
for admission.
Okay.
27.
Oh, Lord, yes,
Admission.
lordship,
Admission.
admission, 27,
27.
obliged.
May it please your lordship. Lordship, I beg to mention item number 27 with the consent of the petitioner, lordship. I'm appearing for respondent number 9. We filed a wakalatnama yesterday.
27.
Yes, your lordship.
You are appearing on behalf of respondent number 9.
Yes, your lordship. Pro forma defendant, lordship. Lordship may grant us some time to look into the matter and take it up after vacations.
You inform the other side.
Yes, your lordship.
Your good name?
Lordship H.R. Das.
Mr. A. Sir does learned counsel for the respondent number 9. With consent from the other side, press for listing the matter on
Lordship, after vacations,
after vacation.
any date.
On
After vacation.
28th October.
Lordship,
After vacation, stating that he is the newly engaged and he has not yet filed the wakalatnama
lordship, we have filed it yesterday, lordship.
today.
Yesterday, lordship. We
Yesterday,
have filed
and yesterday he had filed his wakalatnama. Period is accordingly allowed. Rest is the matter on.
On 28th October.
Okay.
lordship.
May it please your lordship, in item number 35, I filed an additional affidavit on 16th of this month. This is not tagged with the record. I may be allowed to call it from section.
Okay.
And
Okay.
another prayer, if your lordship permit, can I move this matter on at 2 Milot,
Today.
at item number 35?
Okay.
May I please, your lordship? Lordship, I pray for listing of an IA lordship on Monday, 23rd. It is connected in an MEC appeal. We are filing this IA for withdrawal of the money that has been deposited. Obliged, your lordship.
May I please, my lord? My lord, I have filed one arbitration appeal on 9th of September, my lord. I pray for listing on Friday, my lord. This matter relates to, I have filed one petition for appointment of arbitrator that was rejected, my lord.
Hmm.
Next,
Friday.
On Monday.
my lord, in the Monday, my lord, trial court is date fixed for filing the written statement.
Okay. Okay.
Obliged. May it please lordship, for listing, my lord. One, my lord, a CRP matter, my lord. My lord, a next date in MSCT, my lord, and fixed on day after tomorrow, my lord. And I have filed a petition for setting aside the order, my lord, impugned order. So that's why, my lord, kindly tomorrow, my lord. Because my lord, matter has been fixed on day after
Okay.
tomorrow in MSCT 3.
Okay, we'll try. But your matter may not reach also. At your risk, we are listing
then,
it tomorrow. Okay.
I'm allowed on tomorrow, my lord, at 2 p.m., my lord. That
No, we will
tomorrow, my
not
lord,
fix
for
the time.
upgradation, my
I'm
lord.
sorry. Yes.
Obliged, my lord. Then
Ah.
today, tomorrow.
May it please your lordship,
Ah.
I beg to mention a MSc review matter for listing lordship.
When?
Lordship next week, lordship.
Next week.
Yes, as per your convenience, lordship. Next week.
On
Take a date from him.
30 October. 30 September.
30 October,
30 September.
30. Yes. Deep clear, lordship.
May I please your lordship, I beg to mention item 32 daily list.
Item?
32. I am for sole respondent, currently listing the matter before vacation because some instructions are
Before?
added
Vacation?
before vacation, lordship. Some instructions are added.
Item number 30,
32. 32.
32. On the, you are for the,
Sole respondent,
your good name?
D. Colita.
Ms. D. Colita, learned counsel for the respondent. You inform the other side.
Yes, lordship.
With consent from the other side, press for listening the matter. After?
Before vacation, if
Before
possible,
vacation,
lordship.
probably possible.
Any
30
date.
of September, 30 September.
Okay.
30.
Okay. Alias, obvious, lordship.
Lordship, I beg to mention for listing of two IAs, Lordship. These IAs are in connection with a MSc appeal. There is some urgency, Lordship, either tomorrow or on Friday, Lordship. Because Bakija proceeding has started, Lordship.
Tomorrow not possible. Tomorrow is hearing day.
Friday, Lordship.
Friday,
Monday, try it on Monday. Friday, so many cases already.
Monday.
Monday, 23rd.
okay.
Obliged. May it please, your lordship. My lord, matter, it's an MSc appeal.
Hmm.
Can it come on Friday, my lord, in order?
Is there any urgency?
There is some urgency.
Okay, Friday we'll try.
Obliged.
Items from daily list for motion, item number 1.
Yeah, please, your lordship.
Hmm.
The petition is a plenty lordship in the package number 24 is 22 lordship. So the respondent number 1 is the father-in-law of the petitioner and he, without knowledge of the petitioner, mutated his name in the place of the husband and mother-in-law lordship.
Hmm.
And petitioner filed 2 petitions lordship. One for order
Hmm.
13 rule 10 lordship.
Hmm. Okay, volume.
Page 43 to 47 lordship.
Page number?
43 to 47 lordship.
Yes.
For and for all the original document and record from the other court lordship. But in the state petition lordship, the petition submits some wrong provision lordship.
Hmm.
It may be order
Yes. So your petition was dismissed by the trial court.
yes lordship.
So the learned trial court had relied upon section 77 of the Evidence Act.
Yes lordship.
So it is stated that you can produce the certified copies of the public documents.
We have applied lordship. I have applied lordship, but not yes out.
Pardon?
Lordship, the petitioner applied the document with
Yes.
concern authority, but not yes out the document. lordship.
Not?
Not yes out.
Then even if you were allowed to call for the documents, then if the documents are not available with the concerned office, how they would produce it before the court?
Because this document very important lordship for means of justice lordship. And if lordship, as per record available in the office lordship.
Whether your petition for furnishing the certified copies was dismissed by the office?
Lordship not received. Not this.
Then on what basis he was submitting that the record could not be traced out?
We have applied for certified copy, Lordship, before our concerned authority, but they have not provided any document, Lordship.
Have you made any averment in the petition to that effect? That you have applied for the certified copies and you have not been provided with the same?
Page 5, Lordship, paragraph 4, Lordship. The petition stated that after the knowledge about the mutation of data, petitioner approached before the circle officer Shivsagar by submitting representation for cancellation of mutation orders. But till then, no any fruitful result came out from the authority.
No, the averment that you have applied for certified copy and you have not been provided with the same.
No, Lordship.
No averment. Then you make an averment to that effect. You file an additional affidavit. Thereafter, we'll see what can be done.
Till disposal, Lordship, and the state of proceeding, Lordship.
No, stay of the proceeding would arise only when we find prima facie case in favor in your favor. When the next date is fixed.
I have no knowledge, Lordship.
So you file an additional affidavit. Thereafter, we will see what can be done. The pair being made by Mr. Z.G. Gogoi, learned counsel for the petitioner, recessal is the matter after 1 week. So they fix a date then? Okay,
After
next week,
Lordship, 30 seconds.
30. So as to enable Mr. Gogoi to file an additional affidavit in the
Item number 2.
My pleasure. The plaintiff petitioner before Lordship, she was the defendant. Plaintiff filed an application for amendment of his pleading at the stage of argument. And what kind of amendment was sought? That he challenged my cell date, that is cell date of 1997. And already we have filed our written statement and counterclaim also. I mentioned it that in 1997 we purchased. Now at the argument stage, he filed application that we want to challenge that cell date at the argument stage. And it is allowed that impugn order at pace.
no. Is there any bar?
No, at this argument stage, it can be done.
Yes,
There is no any bar.
yes.
Now question was, what is the findings? Because there is negligence on the part of the plaintiff. There is no due diligence. Your Lordship kindly 6 order 6 rule 70.
Mm.
Point. My
Order 6 rule?
70
Yes.
amendment of this. That
Mm.
is,
At any stage of the proceeding.
my lord,
Mm.
provided
Mm.
provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, my lord, that
Mm.
is important.
Mm.
The party could not have raised the matter before the commencement of trial.
Mm.
Where is the, my lord, due diligence? There is no findings in the impugn order that due diligence was there. There was no any findings in the impugn order. And in 1990, in 16, they have filed, we filed our written statement in to the 2017.
Mm.
We have disclosed that we have purchased this land
Buxwood land by registered sale date. Now at 2024, they have come with the pleadings for amendment of the pleadings that they want to challenge that sale.
Hmm.
Can it be said it is due diligence on the part of the plaintiff?
Hmm.
And there is no findings on in this regard.
No, when the respondent came to know about the existence of
In
sale deed,
2017, we filed written statement stating all these things. In 2017.
where is the petition filed by the respondent?
Might. They gave in a plan to the advocate that they did not inform the client here in this petition,
At page number?
page 71. That is their petition.
Paragraph number?
It starts of paragraph number 3. They have explained.
So you show me the petition filed by the respondent before the trial court?
Objection from my objection. My objection at
No, the petition filed by the respondent before the trial court.
yes. It starts from 71. and
71.
Yes. And relevant page, possibly page 76, para 8. It starts, it would be pertinent with page 76.
Hmm.
It would be pertinent to mention here that from the month of June 2023 till the mid of September 23, the presiding was on leave. Thereafter, the instant case was fixed on September. The present set of counsel, while preparing the argument, found that relief brief handed over to them by the petition did not contain copy of the additional written statement as well as the copies of the censor filed by both the parties to suit as well as the cross examination. So they applied for this same on 7/11/2023 and obtained the certified copies of additional written statement, the copies of the censors. You want entire suit to be amended.
So the question is without amendment, whether the dispute between the parties can be adjudicated.
Yes. That can be, but their diligence may be considered by the Supreme Court in 2023. It is
Hmm.
held. And due diligence has been defined in 2008.
No, here it is not that no reason is assigned.
Yes,
assigned,
reason is
but the reason is assigned.
why it is delayed, that is not mentioned. Why?
It is also settled law that for the fault of the council, the party should not
No,
suffer.
that possibly, my your lordship kindly see the Supreme Court judgment
Hmm.
in regards order 6 rule 17. Similar situation arises. Paragraph 8 possibly, my lord, will be relevant. The High Court allowed, but the Supreme Court. Paragraph 8.
The trial court has recorded a finding at the paragraph number 13.
Yes.
Hmm. That the purpose of justice will be fulfilled only when the
Correct.
real question in controversy
how-
are permitted to be answered.
That is how, that is not mentioned. How it be? At the time, I am cognizant of the fact that this belated stage of trial has caused additional delay
Hmm.
to the case. But one has to keep in mind that the purpose of justice will be fulfilled only when real question in controversy are permitted to be answered, and procedural law is therefore nothing but handmade justice. But it is can be a justification, my lord, that in relating to
Why
that.
not? Why not?
So for due diligence, why it was
Hmm.
not placed before, why they did not challenge that cell deed earlier to that, there is nothing mentioned in this. There is no finding. Supreme Court, that is why it is said. There must be findings. What I have understood from paragraph 8 of that judgment. Paragraph 9 also. That being no finding by the court that the court is satisfied in spite of due diligence, the party could not produce amendment before commencement of the trial. In other words, cell deeds, they have challenged, that is time barred also.
Hmm.
It was in 1999, 1997. And now they can challenge that cell deed in 2024. Because they had knowledge in 2017. It should have been challenged within 3 years. On this point also, it is barred.
So only after receiving the written statement, copies of additional written statement, evidence on affidavit and the cross-examination on 17/11/2023.
They want to set that the set of advocate change,
Hmm.
then they receive it. But we have supplied it in the year 2017. How they can say?
No, they stated, no, petitioner stated that he came to know. No, the respondent stated that he came to know only obtaining the certificate copy on 14/12/2023.
Why they have, why not obtain the certificate? We have supplied the copy
Oh,
to the respondent plaintiff. Without supplying copy to the respondent plaintiff, we cannot file a written statement or counterclaim.
no,
In
no,
2017,
no.
Fine.
They came to know about existence of the cell deed number
have-
2893 of
Yes,
1997
we have mentioned it.
only on 14/12/2023.
How can we have mentioned it in our written statement counterclaim that we have purchased the.
But there is change of counsel. The earlier counsel did not inform him. That is the reason.
Petition, the respondent plaintiffs, they know, they knew it.
Hmm?
The respondent plaintiff, they knew it. They've changed the counsel and they have stated that the new set of advocate did not know. How can it be? It is
Where is your objection petition?
my 85. Start. We have stated in our objection that in 2017. And they also filed, my lord, against that counterclaim, they file also written statement. Then also did not stated about this sending. The plaintiff. The plaintiff, my lord, this plaintiff has the claim the suit led on the basis of a gift deed of 1999.
Hmm.
Our case is that, my lord, already we have purchased this land in the year 1997 by a registered deed. Accordingly, we got the possession.
Hmm.
This is our claim in the written statement and
Hmm.
counterclaim. they have, against that counterclaim, they have filed their written statement also. At that point of time, they did not raise any question about my sale deed of 1997.
Mm.
Then evidence laid on this part. Now, at the stage of argument, they have said no, they want to challenge that sale
Mm.
deed of 1997, which was executed in favor of me by the defendant
Mm.
number one. Our purchase is prior purchase than the defendant,
Mm.
and we are positioning the land. And they have filed for declaration of right title interest and recovery of possession. On the basis of that gift deed, that was it is allowed, my lord. And their suit will be changed. Prayer also, the pleadings also, and entire prayer, pleading, everything will be changed. And news,
So what is your written statement?
my lord. Page 20,
Yes.
page, our, whatever, defendant number two, we have defendant number two, that is at page 40. Page 49, we have categorically stated. Page 49, paragraph E, we have categorically stated.
Paragraph number?
My lord, E, page 49. That we have purchased it.
Maybe, but if the earlier council had not informed him, then how
It
he
is not the case of the council, my lord, it is the case of the defendant, sorry, plaintiff. If
Hmm?
it is the case of the plaintiff, my lord, they were aware about this case, aware about this sale deed. They laid evidence also. And
Hmm.
2023, they said, no, council has changed. So they did not have the knowledge of that. Can it be, my lord?
Hmm. But the fact remains that there is one sale deed of the year 1997,
Yes,
and the
that
finding
is
of
my
the
sale deed.
court is that to
It is,
determine the real question of controversy.
that is my sale deed. That is my sale deed.
Hmm.
And they have come,
This amendment is necessary.
that is my sale deed.
Hmm.
After my lord, 6 years, after 6 years, they have come to the court after conclusion of the trial that it may be amended. Why we want to challenge that sale deed? Can it be like? There is no finding of due diligence.
Okay, we reserve the order. We'll see. Or Mr. N. Hope, learned counsel for the
It is
petition.
for the first time, my lord. Notice has not been issued in this. Notice has not been issued in this.
Pardon?
Notice has not been issued in
Okay.
this.
We'll try to dispose of it. Motion is still itself.
My lord.
Order reserved.
Item number 3,
May it please your lordship.
Hmm.
My lord, by this petition, I have challenged the order dated 30th August 2024 passed by the civil judge,
Hmm.
the junior division number 2, rejecting my petition for adjournment, my lord. Your
Hmm.
lordship will find the impugned order at page 12.
So on the date fix, you remain absent.
No, I did not remain absent. Absent, my lord, here.
So that's all
on
right.
that
One
particular-
petition was filed that you were out of station.
Out of station.
Yes.
And in support of it, I, along with the application, I
Hmm.
also filed the air ticket, my lord. Your lordship will find
Hmm.
as page 59.
Hmm.
59. This is the application, my lord. And 60 is my,
At what stage the case is pending?
at the stage of cross-examination of PW1.
Cross-examination of PW1.
PW1. And I'm ready to cross-examine on any date, my lord, as your lordship may fix.
হবে। ভিতৰত একটা ডায়েৰী আছে ডায়েৰীটোত দুটামান হেৰি আছে কাগজ দুখনমান আছে ভিটামিন heard Mr. O.P. Bhatti, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 38/7/2024 passed by the learned Civil Judge Junior Division number 2, Kamrup M. Guwahati, entitled suit number 169 of 2019. It is to be noted here that by impugned order dated so and so, the learned trial court has dismissed the petition number 1656 of 2024 filed by the petitioner for adjournment of the case, and thereby close the cross-examination of PW1. Mr. Bhatti, learned counsel for the petitioner, submits that the case was pending for cross-examination of PW1, but on that day he was out of station, and to that effect one petition was filed. Petition being 1656 was filed before the learned trial court for adjournment of the case, but the learned trial court by the impugned order dated rejected the pair of the petitioner and closed the cross-examination of PW1 in the interest of speedy trial of the matter in dispute. Mr. Bhatti submits that he is ready to cross-examine the PW1 on any date, and therefore it is contended to allow the petition. Having heard the submission of Mr. Bhatti, learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record and also perused the impugned order dated 38/7/2024. It appears that on that day the counsel for the petitioner was absent, and to that effect one petition number 1656 was filed, stating that the counsel for the petitioner is out of station, and to substantiate the same, the petitioner has also enclosed one air ticket, which is enclosed with the petition at page number
Page number 60.
160. 60. Thus, it appears that sufficient cause has been shown for adjournment of the case on 30/7/2024. It appears that the case is pending at the stage of cross-examination of PW1. It is well settled that a right to cross-examine a witness, apart from being a natural right, is a statutory right. Section 137 of the Evidence Act provides for examination in chief, cross-examination, and re-examination. Section 138 of the Evidence Act confers a right on the adverse party to cross-examine a witness who had been examined in chief, subject of course to expression of his desire to the said effect. but indisputably such an opportunity has to be granted. It is also well settled that right to fair trial is a fundamental right. In a fair trial, fair opportunity has to be given to both the parties to the proceeding. Denial of right to no, denial of cross-examination is denial of right to fair trial. Keeping the aforesaid aspect in mind and also considering the submission of Mr. Bhatti, learned counsel for the petitioner, and further considering the facts and circumstances on the record, this court is inclined to allow this petition. It is provided that the learned trial court shall afford another opportunity to the petitioner to cross-examine the PW1, subject of course payment of a sum of rupees 5,000 being the cost, which shall be deposited before the court on next date.
Macho.
Item number 4.
May it please your lordship. The petitioners before your lordship, they had filed a land grabbing case against the respondents before the trial court. Special tribunal at Tinsukia. Now your lordship will kindly come to page 28. Page 28, the order dated 18/9/2023. By this order, petitioner is represented. Petitioner is to take steps, fix 410 for steps report. Now thereafter, lordship's kind to thereafter the orders at page 29. The petitioner is represented and the court had directed them to take steps. These are the orders that were subsequently passed. Then at page 31, the order dated 17/1. It was fixed for 18/3/24 for steps and report. Now this order is important for us. Thereafter on the next date, that is page 36, the respondents appear. They file petition 437/24, prays for time for filing WS, prayer is allowed. Then the next date is fixed on 4/5/24. Now your lordship will kindly come to page 35. This is the petition they had filed, the previous page. Today is the date fixed for filing written statement. The respondents have engaged their lawyer and accordingly court granted them time, fixing the next date on 4/5/24. On the next date, again at page 36, your lordship, respondent filed petition 658, prays for time for filing WS. Fix 4/6/24 for WS. Now your lordship will kindly come to page 38. On 5/6, they again filed this petition for filing written statement. 5/6. That is at page 38, your lordship. Despite best efforts, the opposite party could not able to collect all the relevant documents for preparing the written objection of the as such. The written objection cannot be prepared. So accordingly, they seek another time. Now thereafter, your lordship will come to the order that was passed on 5th of June at page 43. Both the parties are represented by their counsel. Seen a petition number 832 filed by the opposite parties, praying for fixing another date for filing written statement. Seen another petition file 833 for filed by the petitioners, that is us. Under Order 8 Rule 1 CPC, read with Section 10 of the Land Grabbing Act, stating that though the opposite parties have appeared on 18/3 without filing any written statement and failed to file the same within 14 days from the date of appearance, and that the mandatory limitation period of 90 days. Now, in this regard, your lordship, assuming that they for the first time appeared on 18/3, 18/3 was the first date they appeared. So taking that into calculation, by June 16th, their 90 days are over. June 16th. So up to 5th of June, they have still little more time.
Now thereafter, your lordship will come to the last part of page 43.
Mm,
Fix 19.6 for filing written statement with cost of rupees 3,000.
mm,
Then thereafter, on the next date, again a petition was filed on 19.6. That is at page 44, your lordship. That
mm,
today is the date fixed for written statement. The respondent number 2, so and so, is busy in the treatment of his ailing mother, who has been suffering from various ailments, and she could not provide some of the relevant documents. And since the written statement could not be prepared and filed today, so these are the reasons they have cited. Now, your lordship will kindly come to the next order. That is the order passed on 19.6, considering this petition. In the petition bearing number so and so, filed by the respondents for filing it for
At the page number?
page number 45, your lordship.
Yes.
Heard the learned counsel for both the parties at length on this petition. Learned counsel for the applicants has also vehemently opposed, raised objection against this petition. Considering the facts of the case, petition is allowed. However, it is ordered that this is the last and extreme chance given to the respondents for filing written statement, failing which the case shall proceed as per law. Fix 26.6.24 for filing WS by the respondents with cost of rupees 3,000 as ordered on 5.6. Now your lordship will come to page 46. That in pursuance of the honorable court's order of the honorable court, the respondents have filed a written representation oblique written statement against the petition of the applicants. That the respondent number so and so, being a lady, and as such respondent number 2, so who has remained busy with his mailing mother, so and so, as such, he could not collect and provide the relevant documents in form for preparing the written. As such, they have not been able to file the written statement on the last dates, for which your honor was pleased to allow the respondent to file written statement with cost of rupees so and so. That the respondent stated for non-filing of the written statement on earlier dates was not all intentional and due to the circumstances beyond their control. As such, respondents filed the petition, this petition, praying for waiving the cost.
Mm,
This is the crux of the matter in this petition. They want to waive the cost. Accordingly, the last order was passed, page 48, your lordship.
mm,
The respondents have jointly filed their written statement today along with documents. The respondent number 2 has filed a petition number 933 stating that the respondent is an aged lady and has been suffering from various ailments and remained busy. The court recorded the observations made in the petition. Now the order that was passed eventually. Heard the learned counsel and the prayer is allowed. The cost imposed of rupees 3,000 is waived. The written statement filed today is accepted on record. A copy of the written statement be furnished to the other side.
mm,
Now thereafter, the matter stood fixed for documents and issues. Now our submission is that, your lordship, after they have been extended the time beyond 90 days, with cost, it has been allowed to file. Instead of rejecting the prayer they have made to file the written statement beyond 90 days, the court on a prayer made by them had even waived the cost along with accepting the written statement filed by the respondents.
mm.
So which is not the mandate of order 8, rule 1 of the CPC, allowing the respondents to file a written statement. Because if your lordship reads the provision of order 8,
Mm,
the defendant shall file within 13 days from the date of service of summons on him, present a written statement of his defense, provided where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing, which shall not be later than 90 days from the date of service. Now, in this case, the court
maybe, but there are several judgments of Supreme Court where it is stated that if sufficient cause is shown, then a written statement can be accepted beyond 90 days.
it can be.
Yes.
It can be, but what practice that prevented them from filing?
Mm.
Because if your lordship
No,
consider
in the petition it is stated that
Ailing
mother,
he was looking
the
after.
respondent number 2 is a old lady. Is
Now,
an
in
old
this
lady.
regard, may I just point out one thing? Due to some inadvertence with the petition that was filed as annexure annexure 13 at page 46,
Mm,
Now, there are some medical documents also.
mm,
Now, I did not submit those documents,
mm,
but the certified copies are here with me. I just want to annex those documents here
mm,
with this petition.
mm,
Here, your lordship, the documents that were shown, the medical reports are all normal. And it has been suggested by a dentist.
mm,
The dentist has nothing to do with high blood pressure, low blood pressure, and other things that have been stated in the petition.
mm.
Those medical documents are not relevant documents.
Maybe, but have you raised this issue before the trial court?
No, court did not hear us, did not give any opportunity.
Why?
Your lordship will kindly peruse the order.
Mm,
First, I'll draw your lordship's attention to page 45,
mm,
annexure 12, your lordship.
mm,
Third paragraph. Heard the learned counsel for both sides at length on this petition. The learned counsel for the applicants has valiantly raised objection against this petition.
mm,
Considering the facts of the case, petition is allowed.
mm,
If your lordships consider the documents supported by the documents that were supporting the petition 900 of 2024,
mm,
these are all irrelevant documents. Documents have been medical records pertaining to suggested by a dentist.
mm.
Dentist has nothing to do with the ailing mother's medical. Had it been by a qualified doctor in the medicine, in the field of medicine, that is different. These
Hmm.
documents are not relevant.
No. What was the ailment of the mother of the respondent?
Nothing has been stated. Your lordship will kindly come to that page, that petition number 900.
Mm,
Page 38, your lordship.
mm,
Initially, they were taking time on the ground that they could not collect the
Petition
documents.
number 900. Page number 44.
That 900 is at page, your lordship, 44.
Yes.
Now, your lordship will have to examine the different petitions filed on different dates. Besides the petition at page 44, your lordship will kindly take note of the petition at page 38.
Mm,
If the language of page 44 is taken into consideration, it is
Hmm.
said that he was busy taking after care of his aged mother.
mm,
But your lordship will take a note of page 38. In page 38, the ground is totally different. That despite best efforts, the opposite parties could not able to collect all the relevant documents for preparing the written objection. Normally, an elderly lady suffering from age-related ailments,
mm.
it is a prolonged affair. And and what are the relevant medical documents that were supported by this petition number 900?
Mm.
And the reports are also normal. Just for the purpose of satisfying the
No,
court.
but the problem is that you have not made any such averment in your petition and also not enclosed the medical documents which your
Yes,
petition.
we have made.
Where?
Page 14, your lordship. Page 14, para 14. That your petitioner submit that onus upon the respondents is of a higher degree to plead and satisfactorily demonstrate a valid reason for not filing the written statement within time.
Mm,
A perusal of the medical documents enclosed to the petition 900/24, that is annexure 12, reveals that test reports of respondent number 1
mm,
are within the normal range, which was referred to by a dentist.
mm,
Admittedly, therefore, no extreme hardships or factors beyond control of the party have restrained the respondents from filing the written statement within time, despite proactive diligence. That is the language of the Supreme Court, your lordship.
mm. But have you enclosed the medical documents
Yes, your
in
lordship,
support
for
of
some
this
reason
averment?
inadvertently it was left. I just wanted to make it.
You file an additional affidavit?
Yes, your lordship.
We'll see. Heard Mr. A.K. Chaudhary, learned counsel for the petitioner. Mr. Soturi submits that he will file an additional affidavit bringing on record some medical documents of the respondent number 2. Respondent number 1 or 2? 1.
Medical documents of respondent number 1.
1. And press for granting him some time. Pair is allowed. List the matter on when? After a
Next
week?
Your lordship. Next week,
Next week. Monday?
Monday, maybe little short, maybe on
When is it?
Wednesday, 25th. Oblige your lordship.
Number 5.
May please your lordship. Your lordship, the respondent here had filed a money suit against the petitioner here. The claim of the respondent is based on the basis that we have violated the lease deed. And the lease deed was annexed with the plain copy. But the lease deed also.
So on the other day also you
Yes,
filed
yes.
similar
Yes,
application?
similar petition. But this here.
So
lordship, there-
similar order is to be passed.
Yes, your lordship.
Where is that order?
Yes, I have done. Here, only thing we had not filed a WS along with this. There we had filed a WS along with the section 8 petition. So that issue has to be decided. Here we have filed section 8 and your lordship, we have also brought on record the original subsequently at page, your lordship will see it. Because we had craved leave in our section 8 petition to produce at the time of hearing accordingly at page 121.
Okay, similar order.
Here we have brought the original on record subsequently, before hearing. At page 121. Okay. Impugn order is at page, your lordship. 124.
Okay.
Oblige, your lordship.
Number 6. Lordship, in this petition, Lordship, we have challenged the order passed by the learned member MSCT Kasar Lordship. Order is in page 15, Lordship. In this case, Lordship, as per amendment of the MP Act, limitation period is 6 months from the date of accident, Lordship. But in this case, Lordship, that is filed beyond that. In fact, accident took place in the year 2020.
It is an accident case or death case?
Lordship, it is a death case, Lordship.
Death case.
Yeah.
Now tell me whether any FIR has been registered.
The PS case.
What is the number?
Lordship, Lakshipur PS case number 47, 2020. Page 22, Lordship. I have annexed the claim petition, Lordship.
So the accident of this case took place before coming into force of the new Amendment Act.
Yes, Lordship.
But there is one judgment of Supreme Court where it is stated that the investigating officer has to prepare this accident information report and forward the same to the learned tribunal.
Yes, sir.
And on the basis of the same, the tribunal can register a case and proceed to hear the matter.
Yes, Lordship.
If that is the position, where is the question of delay?
Lordship, I have no instruction, but that might not have been sent, Lordship. Otherwise, one case would have been registered in the concerned MSCT, Lordship.
But even then, this FIR was forwarded to the court.
Yes, Lordship.
And the FIR was filed immediately after the accident.
Lordship, I have no instruction in that regard, Lordship.
You obtained necessary instruction. You appraise this court on next date. Heard Mr. A.J. Soikia, learned counsel for the petitioner. List the matter next week. So as to enable Mr. Soikia to obtain necessary instruction in respect of the date of filing of the FIR and forwarding of accident information report to the member MSCT Silsor, Kasar Silsor.
At number 7.
May it please, my lord. And I'm referring this present petition on being aggrieved by an order passed by the learned civil judge, senior division number 3, Kamrup Metro, in an application under order 9 rule 7, my lord. The
Hmm.
order, my lord, will find it page number 24. Oh, sorry, my lord, 108.
Yes.
This is the order, my lord, that has been passed. May I read it, my lord? The petitioner number so and so is filed by the petitioner defendant under order 9 rule 7, read with section 151 of prayer for setting aside of the order in review of the order dated 21/11/2022 and 5/7/2023, passed in title suit number 39/2012. The contention of the learned counsel for the petitioner defendant is that the main suit, that is title suit number 39/2012, has been filed against the present petitioner along with the other defendant, one Khoghen Sharma, who is also a party to the present suit, had approached the petitioner defendant with a proposal to file a joint written statement. According to petitioner defendant, along with Khoghen Sharma, appointed a single set of counsel. Khoghen Sharma was the sole point of contact between the petitioner and the counsel appearing for them, and he assured the petitioner that as the petitioner could not come regularly to the court, he would take care of the entire case proceeding and also would inform the petitioner as and when required. In the year 2013, the petitioner filed the written statement along with the said Khoghen Sharma and was in contact with him regarding the proceeding of the case. But later the petitioner could not contact Khoghen Sharma as he stopped answering a phone call. But she was assured that she would be informed about any crucial proceeding of the same. Upon inquiring, the petitioner defendant came to know that Khoghen Sharma died on 25/10/2019 and the counsel of the present petitioner stopped appearing on that case. And as such, the case has proceeded ex parte against the present petitioner without cross-examining the PW and without adducing any defense witness. Hence, the petitioner plaintiff had preferred the instant petition for setting aside order dated 21/11/2022, 5/7/2023, passed in title suit number so and so, and thereby allowing the defendant to contest the above mentioned suit for cross-examination, cross-examining the PW, adducing evidence, defendant witness, and thereafter by advancing the argument in this case. The opposite party plaintiff had filed written objection against the instant petition, stating the inter alia that a similar petition was filed earlier by the petitioner defense on 17/1/2024, which was registered at miss case number 60/2024, which has finally heard and disposed of on 29/2/2024, whereby the petitioner was rejected by the court. Hence, a similar petition was almost similar.
So now you tell me, for what reason you could not appear before the learned trial court from 21/11/2022 till 5/7/2023?
And the reason being is that there are set of defendants who have filed a joint written statement. And there is one person, defendant therein, Khoghen Sharma, who was taking lead of the entire matter. I was in constant touch with Khoghen Sharma, and he was the person who was in touch with the council concerned. So, but very unfortunately, Khoghen Sharma stopped answering my call, and I had some other matters also relating this particular issue, which is before the court. When I engaged the present case set of counsel and inquired about the matter, then I got to know that this matter was already proceeded ex parte, and Khoghen Sharma has died long back in 2019. After procuring the certified copy, I immediately approached the court by filing an application under order 9 rule 13, which was my lord, subsequently which was disposed as order rule 9/13 is not maintainable. Subsequent to which again I went to the trial court, and my lord filed this present application, and this particular order is being passed. Now, my lord, the observation.
Now, what is this? The case is pending.
My lord, it is fixed for arguments, my lord, final arguments. It is fixed on 26/11/2024, my lord. In fact, it was fixed yesterday. I have been told that one of the counsel have argued, my lord, the petitioner has argued, I have filed the petition.
Let notice go at this, is this?
My lord.
Pardon me, sir, Senso, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with section 115 and section 151 of the Civil Procedure Code, the petitioner has put to challenge the correctness or otherwise of the order dated 24/6/2024, passed by the learned civil judge senior division number 3, Kamrup M, in Mizje case number 360 of 2024, arising out of title suit number 39 of 2020. 39 of 2012. It is to be noted here that by it in order dated so and so, the learned trial court has rejected the petition filed by the petitioner under Order 9 Rule 7, read with Section 151 of the CPC. To recall, the order dated 21/11/2022 and 5/7/2023. Whereas the petition and the documents placed on the record, let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a period of 3 working days from today. List the matter after 4 weeks, and considering the submission of learned counsel for the petitioner, and also considering the facts and circumstances on the record, further proceeding of title suit number so and so stands state till returnable date. List after 4 weeks.
Briefly obliged, madam.
Order number 40.
My lord, this application is directed against an order whereby my objection under 47 of CPC was rejected by the learned executive court. Before I go to other assessment matter, I'll briefly list the facts. What happened at the respondent number 1? As plaintiff, he filed a summary suit against the petitioner as defendant number 1 and respondent number 2 as defendant number 2. Plus summary suit was filed. And basis of filing this summary suit was 2 documents. One is deed of agreement, another is deed of declaration between the respondent number 1 and respondent number 2. The petitioner was not a party to the agreement. So without making petitioner a party to the agreement, a decree was passed. Summary suit, summary decree, order was passed. Ex parte, that is, that was also ex parte. And an application for setting aside the ex parte decree and for placing our defense under Order 37 was filed. That was also rejected by the court below. Then, Lordship, so we kindly see in the agreement, there were several emission of facts. Like that the agreement was entered into between 2 parties, respondent number 1 and 2, number 1. Secondly, the respondent number 2, although it was not a company, it was described as a company registered under the Companies Act. And one Hoshmukh Patel, he was described as the managing director of that particular company. So we will kindly turn to the agreement. Annex 58. Page 58. Annex 4. Page 58, that is only type copy because the original copy was not legible. Has also got it?
Got it.
Page 58. That is the deed of agreement is made on this between, also will kindly consider this, between Messrs. Ambalal Properties and Investment, a company duly registered under the Companies Act 1956, represented by its managing director, Sri Hoshmukh Patel. Now, it is between, then will kindly skip over and come to page 60. Between Messrs. Monastic Company, that is the plaintiff, and the declarer, a proprietorship concern represented by his proprietor, Sri Binod Kumar Bengani, son of so and so, resident of so and so, Guwahati. Hearing after call, second party, which expression shall follow so and so. Whereas the sister concern of the first party, namely Duluti Company Limited has taken a loan from the second party, but since the aforesaid sister concern of the first party has no immovable property in its own name at Guwahati, to mortgage the same to the second party as a security towards repayment of the aforesaid loan amount, the first party hereby agrees to mortgage the land as described in the schedule in favor of the second party towards repayment of the aforesaid loan amount to the second party. And the second party has also agreed to accept the mortgage of scheduled land by first party in favor of the second party on terms and conditions as mentioned below. Now let's continue on to the next paragraph. Now this agreement witnesses that the second party has paid to the opposite sister concern of first party a sum of rupees 40 lakhs by demand of number blank. Blank demand draft, that means no amount was paid. So it is between the two parties, that is respondent 1 and 2. Although the petitioner was not a party, the petitioner's name was mentioned as sister concern of the Ambala property, that is respondent 2. Now we'll call it down to the plaint. Plaint as page 39. Page 39, annex 2.
Yes.
Here, the defendant's name are mentioned. Number 1, Duluti Company, the petitioner. Number 2, Masas Ambalal Properties and Investment. That is, the defendant number 1 is a public limited company incorporated under this so. And defendant number 1 is public limited company, and the defendant number 2 is a partnership firm registered under the Indian Partnership Act 1932. So how can it be? If there is a company in the name of Ambalal, how it can be again converted into partnership firm? Meaning thereby that there was no company in existence. Only Hospo in coalition of the monastery company, that is the plaintiff, lordship, they filed a suit. So that fraud they have committed. And the money is sought to be taken out. Money belonging to the petitioner company. It belongs to the company, lordship. It does not belong to any particular individual. Maybe he may be director or managing director. It doesn't matter. One resolution has to be adopted. Now, lordship will kindly turn to another document that is at page 58. No, 55, sorry. These are two documents on which the decree was obtained by playing fraud. 55, lordship.
Page number
55.
55.
Annexure 3.
Yes. Declaration.
Declaration. Hospo Patel, that is same person. Same person, son of so and so, managing director. He is not the managing director. Admittedly, he is only a director. I'll come to that later. He is a director, maybe. Company duly registered under the Companies Act. Its registered office at so and so and branch office at Dulu so and so. This is to hereby declare that opposite company has taken 40 lakhs. Again, same thing. Declaration. By so and so, then next, civil condition.
So anyway, the decree was passed.
Decree, particularly decree was obtained, decree was passed, then it was thought to be.
Decree was for a sum of rupees.
Initially, it was 54 lakhs.
54 lakhs.
Now it has come up
with
to,
interest.
now it has come up to 1 something with interest. Now, what has happened is, so since they are mortgaged, the property belonging, personal property belonging to the respondent 2, that is Osmo, was mortgaged as per the condition clause 5 of the agreement. Since it was mortgaged, so it was sought to be enforced against him. There are two aspects of the matter. And it was sought to be enforced against him, and there was a direction by the Honorable Court, Executive Court. Lordship, you will find that in Annexure 8. Page 84.
Page number
84.
84.
I do not have any objection if it is executed against the respondent 2. because the steps were taken to execute the decree against respondent 2 first initially. Lordship will see at page 84. Case record is put up today as it was not put up on its fixed date. The decree holder is represented and through petition number so submitted that concerned circle officer may be directed to execute the writ of attachment on the basis of old DAG and patta number by comparing the new DAG and patta number. I have paid the order to so height which it was directed the circle officer concerned to produce new DAG and patta number of the concerned property. It was submitted that the concerned Mondal has failed to identify the concerned property by which the writ of attachment was issued. Considering the materials before this court, at this stage, it is directed that the writ of attachment issued earlier will be executed. After comparing of the old DAG and patta with the new DAG and patta of concerned property on the basis of land revenue record available at the office of the circle officer concerned, fixed so and so so and so. Thereafter, Lordship, they did not take any steps on this. When this fact was raised in our objection, order 47, section 47 objection, then they said that the decree holder, that is the petitioner, they should cooperate to identify the land. If they cooperate, it is okay. Then Lordship will kindly see the statement made by them. At page 105.
Page number?
105. Paragraph 40. Is there their
Yes.
objection against our application? That the statements made in so and so petition under reply are not true and just the same are denied. It is respectfully stated that the decree holder has made the payment of loan amount to judgment debtors, believing bona fide and in good faith, and he had not even seen the property of which the documents were given to him as security. And during the execution proceeding, when the bailiff of this honorable court went to execute the writ of attachment of the said property situated at Beltola, Guwahati, it came to the notice that the said property could not be identified as that number given in the documents to the key holder were different from the current tag number. And the judgment debtors are liable to identify and assist the plaintiff of the honorable court to attach and sell the said property if they so desire. So they wanted that we should cooperate. Yes, we are ready to cooperate, and Lordship will see our reply 112, page 112. In paragraph 9. That with regard to the statement made in paragraph 14 of the written option to the judgment of number 1 state that although it has no knowledge about the land allegedly mortgaged by ZD number 1 in the decree holder, but as per the law for execution, first of all, the decree holder should pursue to attach the property of ZD number 2, because as per the ZD number 1, same will cover the decretal amount, and the ZD number 1 is ready to cooperate in whatever manner it can for attachment of the said property. Moreover, on perusal of the authority, it appears that the key holder was directed that writ of attachment issued earlier will be executed after comparing the old DAG number, new DAG number, but the decree holder did not take any steps. So the midway they abandoned that proceeding. Now by abandoning that proceeding, now they have sought to execute the decree against the petitioner. Because some money was lying with the deputy commissioner as compensation, which was paid to them as for land acquisition. Some money was pending there before the decision, and that money was attached suddenly. And we came to know about the enforcement of the decree only when the attachment was made. That was in the year 2022, on 18/5/2022. Then we filed our objection. Then that objection, without considering all the aspects of the matter, the learned executive court, he just rejected the application on some extraneous and irrelevant consideration. And I can come to the judgment. It is a very lengthy judgment. It will require some detail here.
Mm.
What I suggest is that my learned friend, since he has already appeared, so he may file his counter and within a short time the whole matter will be heard. And in the meantime, my lord, the money which is lying before the court, the money belonging to the petitioner may not be released. And in the meanwhile, they may be given liberty to proceed against the judgment too. So justice will be made. The money is already there. They are not going to be prejudiced. Money is already there, lying. Let it lie. Let it be there. We do not object. But in the meanwhile, during the pendency of this revision petition, lordship, that order may be kindly be passed. Otherwise, the detailed hearing will be it is required long hearing. Big judgment order. I'll attend to all the finding of the honorable court. How the judgment was passed.
Yes, Mr. Gore.
My lord, my lord, sorry to say, my lord, my friend has not come with clean hands, my lord. I just, lordship may have a look at page 55, my lord.
No, yes,
my lord,
Mr.
my
Gore,
lord,
you file objection.
No, my lord, this.
We'll hear.
Yes, my
Wait
lord,
a short time.
my lord,
Huh?
no, my lord. Basically, my lord, the contents of the petition is that he did not receive the money, my lord. The money was taken by Mr. Patel in his personal capacity, my lord. And that because of the fact, my lord, that in the one agreement, it was mentioned that the Mr. Patel was managing director of the company. That was not a company, it was a firm, my lord. My lord, both this declaration and the agreement, my lord, both were get typed and or prepared by the, my lord, this petitioner himself, my lord. And my lord, just, my lord, they say that Mr. Patel did not have the authority to receive the money, my lord, from the decree holder, my lord. My lord, this very declaration, my lord, page 56. This
These
declaration.
amendments are not there. I'll come to the judgment.
No, I will take only 5 minutes, my lord.
And these are not considered by
I'll take only 5 minutes. My lord, the only question that whether Mr. Patel has taken the money in personal capacity or on behalf of the company, that is the crux of the matter, my lord. And my lord, secondly, my lord, that Mr. Patel did not have the authority, my lord. No, my lord, let us have the look at page 55, my lord. 55 is a declaration, my lord, given by Mr. Patel as the managing director of the petition, my lord. Petition is a company, my lord. There is no dispute that the petition is not a company, my lord. Petitioner is admittedly a public limited company, and Mr. Patel, Ashok Patel was at that time, he was one of the director, my lord. And my lord, page 56, my lord. Page 56, my lord.
declaration blank.
Not declaration, my lord, page 56, my lord, he has issued, my lord, apart from executing this declaration, my lord, Mr. Patel has issued 5 checks, my lord, 5 post-dated checks for the repayment of the loan, my lord. And all these checks have been issued from the account of, my lord, the petition company and has been signed by Mr. Ashok Patel, my lord. So impliedly, my lord, if we consider this declaration as a whole, my lord, the plea of the petitioner that Mr. Patel did not have the authority goes away, my lord. Because, my lord, if Mr. Patel had the authority to withdraw money from the bank, my lord, how it can be said that he did not have the authority to receive money from somebody else, my lord. And secondly, my lord, that this agreement was made by Mr. Patel and it was written there as he was signing as the managing director. Although that firm is Ambala Property is only a partnership firm, my lord. So that also, my lord, that document was prepared by them, my lord. That it by Mr. Patel or my lord, it ought to have been I have not, my lord, I have not objected when Mr. Katini was. And all these facts has been admitted by my lord, his own witness, my lord. By his own witness, he has admitted, my lord, that in the year 2005, when, my lord, they allowed the suit to proceed ex parte against them, my lord. In the year 2005, my lord, about 100 acres of land was, my lord, acquired by the government, my lord, for national highway, my lord. Then some money was deposited before the Deputy Commissioner Kachar. We got that money attached, my lord. Then they appeared before the learned executing court. They filed an application under Order 37, Rule 4 for leave to defend the suit, my lord. That application was rejected after, my lord, giving full opportunity, they adduced their witness also, my lord. And that petition was filed, my lord, both, not only by the petitioner, my lord, petitioner as well, my lord, the respondent number 2 here, my lord, both the company and the firm, both have filed that petition, my lord. So, my lord, how he can say that this Ambala property was not connected, this petition has nothing to do with the respondent number 2, my lord, and my lord, his own witness, my lord, page 155, my lord. Page 155 is the cross examination, so his witness, my lord. Well, the last portion, my lord, just last paragraph, may I read, my lord. As per my knowledge, JD number 1 and 2 are not sister concern, as JD number 1 is a public limited company in which the shares allotted includes 25% outsider of the Patel family, and JD number 2 is a HUF or a partnership firm and 100% owned by Patel family. Both petitioner and JD number 2 are my lord, owned by Patel family. The said Patel family included Asmukh R. Patel, Harish R. Patel, among other family members. And in JD number 1, 75% of shares are held by Patel family. It is correct that PW number 1 in Miss Case number 52 of 2006 correctly stated that Asmukh R. Patel and Harish R. Patel are the director of the JD number 1 company, my lord. This, my lord, this Harish R. Patel is still, he has just, my lord, resigned from the directorship in their, my lord, 2016. So, my lord, how they can say that the JD number 1 and the
Okay.
2 are...
Okay, Mr. Gore, you file objection.
No, my lord, my lordship, may I hear the entire matter, my lord?
Yes.
So, my lord, so my lord, their contention that Mr. Asmukh R. Patel, at the time of taking money from me, my lord, and while executing, my lord, the declaration and agreement was executed on behalf of, my lord, the JD number 2, my lord, as a guarantor, my lord. In fact, my lord, while taking the money, because it was a huge amount, 40 lakh in there, my lord, 2003 was a heavy amount, my lord. So they not only issued post-dated check, my lord, but they, to my lord, secure my money, my lord, repayment of my money, they also executed it, my lord, as a mortgage deed, my lord. That is the agreement for mortgage, my lord. Saying that they have about 4 bighas of land in Beltala area, my lord. But and it was the repayment of that property was also, my lord, given as a mortgage, my lord. So, my lord, on that basis, we made the payment, my lord, and when they failed to make the payment, then, my lord, we proceeded. We also filed, my lord, the enact case, my lord, that is also pending, my lord. Now, my lord, not only the check, 5 checks were given in the declaration also, my lord, but those checks, my lord, when we presented those checks, my lord, they got dishonored, my lord. Those checks were, my lord, drawn on State Bank of India, Silchar, my lord. Then, when these checks, my lord, get dishonored, we intimated them, my lord. Then they issued fresh check on UCO Bank, Calcutta, my lord. So, my lord, how they can say, my lord, while issuing the two times the, my lord, checks, how they can say from the petitioner company's account, my lord, how they can say, my lord, that this Asmukh R. Patel did not have the authority to sign the check, or, my lord, to sign the declaration, my lord. And the learned executing court, my lord, he has passed, my lord, the order in 27 pages, my lord. He has dealt with all the, my lord, in details, my lord. The only, my lord, their submission, my lord, that we tried to get the decree executed against the JD number 2 for attachment of the property at Beltala, my lord. It is true, my lord. But, my lord, we tried, my lord, from all angles, my lord. Even, my lord, some amount of subsidy was also payable to the petitioner hearing from the net fee, my lord. We also tried to get that money attached, my lord. When we get that money attached, my lord, this very person, my lord, the PW here, my lord, their own witness, my lord, he is a chartered accountant, my lord. His son, my lord, he, my lord, manipulated a company and handed over the garden at Silchar, my lord, to his son's company, my lord. So his son is managing the garden, my lord. So, my lord, when we get this, my lord, subsidy amount attached, they file an application through net fee, my lord. Net fee contested the case.
Net pay nothing to do, my lord. Net pay to obey the orders of the court, my lord. But they contested the case. In the meantime, my lord, they got issued some notices, demand notice from Celtech department, my lord. That such and such amount is due to the Celtech department. So the priority has to be given to the government, my lord. So the net amount lying with net fee has to been paid to the Celtech department of government of Assam, my lord. So we remain empty-headed. Now, well, when we tried to attach this property, my lord, we came to know, my lord, that this property was purchased in their, my lord, 76, 77, my lord. And mutation was not done. So neither, even, my lord, the revenue officials were unable to, my lord, identify the property, my lord. Because if they did not get the mutation after purchasing it in their 1976 or 77, the person in whose name, my lord, this property was existed, they may also sell it to some other persons also, my lord, or during all these, my lord, 40, 50 years, my lord.
Okay.
So, my lord,
Or
there is no
research
case,
also
my lord, for stay, my lord.
Petitioner and Mr. Jessica, learned counsel for the respondent. This petition.
And one more thing, my lord, they have also filed a suit, my lord, for cancellation of my decree, my lord. That suit is also pending, my lord. Suppose, my lord, the ultimately this petition goes in their favor, my lord, and my decree is set aside. First, my lord, I am ready to execute an undertaking or bond, my lord, that in case it goes against me, my lord, I am ready to refund the money. Alternatively, my lord, he will get the decree. If my decree is set aside in the suit filed by him, my lord, he will get a decree, my lord, and he will realize this money from me, my lord. My lord, I am waiting for this money since, my lord, 2003, my lord. First, you will see, my lord. Now, whenever some my lord, some money is trying, we are in the hope of getting some money, they jump into some sort of petitions and get it delayed.
Okay. This petition under section 115 related section 151 of the Code of Criminal, Code of Civil Procedure is preferred by the petitioner, MS Dulu Tea Company, India Limited, against the judgment dated 9/8/2024 passed by the learned civil judge number 1, Senior Division Kamrup and Guwahati in Media case number 492 of 2022. It is to be noted here that by impugned judgment dated 9/8/2024, the learned trial court, executing court has dismissed the objection filed by the petitioner. Stroke judgment dated number 1 in money execution case number 1 of 2006. Peruse the petition and the documents placed on record. And also peruse the impugned judgment and order dated 9/8/2024. Let notice be issued to the respondent, returnable in 4 weeks. Should we fix it before vacation or after vacation?
My lord,
Because there is another respondent here. Notice is to be served.
You are representing both the
no,
respondent?
my lord, that is, my lord, their own company, my lord, their own
No,
firm, my
not
lord.
mine.
No,
yours.
yes.
It
Their
was
own
in possession
company.
of that company.
Their
Acha.
They will not appear.
Then 4 weeks. You were representing one.
One.
Since Mr. Jasigor, learned counsel appears and receive notice on behalf of respondent number 1, no formal notice is required to be issued. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 2 be taken by registered post with AD and also by usual process within a week from today. Recessal is the matter after 4 weeks. Caveat would be heard. Caveat is
And in the meantime, my lord, that money lying with.
Pardon?
That money lying with the.
No, my lord.
That should be this.
No, my lord.
This
My
month.
lord, in the criminal case, my lord, in the criminal case,
Because
they-
let me.
No.
That petition is fixed on 21/9, next Saturday. So until and unless that disbursement is stopped by this honorable court.
No.
And this will become enforcement.
No, my lord.
Disbursement of the money which is deposited into court by the petitioner company, that should be stayed.
No.
That should be stayed. Otherwise, my petition will.
I'm ready to execute bond,
Will record your objection.
Yes.
No. No, my lord, the amount can be released on submission of bond from the decree holder, my lord.
He will not-
On next date, I will say you file objection.
Yes. Number 8 for admission.
Lordships. I have put the respondent number 6 and 7.
6 and
7, I have filed a objection in I8.
Lordship may very well peruse order dated 9/5/2024. Your Lordship in IA, if your Lordship peruses IA 3435/23, your Lordship.
That was for
There was a-
vacation of the interim order. But on 9/5/2024, the Honorable Court took the decision that the main petition should be heard. Otherwise, it will be delayed.
Your Lordship, however, in the second paragraph of that particular order, it was also observed by the Honorable Court, your Lordship, that the learned counsel for the petitioner prays for a short time to enable him to file an interlocutory
which order?
9/5/24, your Lordship, in the same interlocutory application, which is your Lordship 3435/23, your Lordship.
Order dated
9/5/2024, your Lordship.
Yes.
Your Lordship, during the course of the hearing, it was also further being argued by the state respondents that the school managing committee of the particular school needed to be implemented. So therefore, your Lordship, I had filed an interlocutory application in compliance of the order dated 9/5/2024. Your Lordship, there is one issue, which is that, your Lordship, in case of provincialization, your Lordship, the school which was in issue in the writ petition has already become defunct, your Lordship, because the teachers of those schools who have been provincialized have been merged with the pay school as per the Act of 2017, Provincialization Act, your Lordship. So because of the school managing committee of the erstwhile Bodopa Upendranath Brahma being defunct, your Lordship, I had to implement, your Lordship, the new pay school, which is, your Lordship, the school managing committee of the number 115 Zaripar LP school, because that is the pay school as per the Provincialization Act. I'll just take, your Lordship, in a while the very sections which defines the pay school, your Lordship. The private respondents have filed a written
No,
objection.
thereafter, whether you have implemented the said school management committee.
I have filed an application. On the last occasion, the private respondents, they sought time to file their written objection against that affidavit in opposition, which interlocutory application, which I have filed for implementation, your Lordship. So, your Lordship, now this.
I have filed. Lorships.
When?
That is already been filed. Then Lorships. Filed 1/38/2021. Affidavit on opposition.
I like to file an affidavit in reply to that particular.
Namely, Narachandra Brahma and Luisandra Brahma against IA number 2098 of 2024. Mainly para 3 and 4 Lorships. Para 3 and 4. Case
Where is that affidavit?
Affidavit, sir.
Affidavit reply.
17, a reply, Lorships. Para 3, page 17. Affidavit, Lorships.
In the main petition?
No, Lorships. Reply in IA.
I number
2098. 2098.
Page number?
page number 17. Para 3 and 4, 3. Page 3, that 9/5/2024 Learned Council prayed for short time to enable him to file an interlocutory application for improvement of School Management Committee of Bodofa Upendra Nath Brahma ME School, Jaripar, under Tihu block in the district of Paksa. And 4, number 4, that the petitioner without compliance with the court order dated Iman filed an IA, file number so and so, praying for improvement of School Management Committee of 115 Jaripar LP School, not Bodofa Upendranath Brahma ME School. The provincial was for the school of Bodofa Upendranath Brahma ME School, and SMC of Bodofa Upendranath Brahma ME School recommended for provincialization for teachers, not this school. LP school base school. There is no so much of students. Due to lack of students, they are appointed. They are appointed in the base school, that is LP school. So it is devoid of merits. SMC Bodofa Upendranath Brahma School Jaripar recommended the names of Lohit Chandra Brahma and Naras Chandra Brahma, provinces of their services as teachers, but not SMC of Jaripar 115 LP school. So it is only for delaying, and we are not paying any salary from 24/8/2021. Only 3 years gone. We are doing our duties regularly, punctually, without any pay, and that the petitioner not doing any duty neither in the main school, original school, nor in the base school, and so Honorable Court on 9/5/2024 took up the main case for disposal. Otherwise, it will delay the proceeding, and we are also getting nothing, though we are servicing for a long time. And one of the respondent, this is respondent number 6, he will retire on 31st July of 2025. Only 10 or 11 months left to retire. And another respondent number 7 is headmaster. He is headmaster in doing his duties from the very beginning. All of 3, that is petitioner as well as the respondent 6 and 7, appointed on the same day and joined on the same day. And whatever ground cited in the writ petition.
Now you tell me, without their implement, can we hear and dispose of the matter?
No, Your Lordship.
Lordships, for merit purpose, lordships, because here they are arguing, they are saying that he is doing social studies as a social studies from the very beginning, but no documents is given. I have given so many documents that I am from 2009-10 to 2013. I am doing as social studies teacher, and from 16 onwards, he and I am, that is head teacher as well as the petitioner, jointly doing social studies subjects, and only he was second most meaning on the same day, but only 10 or 15 minutes earlier he joined in the school. That is the ground only. There is no ground, and I am I am headmaster. I am doing social study as per the code. UDAS code will say. UDAS code will reflect that I am headmaster and I am doing social studies. And from where he is claiming that I am doing from the very beginning, that is 1993, I am doing as a teacher of social studies. This is misleading statement only.
Lordship, it was in fact the school management committee which degraded the petitioner from position number 2 and upgraded him to position number 2. So it is the school management committee which is in favor of this private respondent. I don't know why he is objecting the implement of the school.
Yes, Your
management
Lordship.
committee. So let the school management.
Yes.
Yes, Your
Why
Lordship.
the management committee degraded him and upgraded him. Let the school management committee say.
But
Yes.
not the base school.
Your lordship, only one
The
aspect.
provincialized school, that committee is no longer there.
Yes, your lordship.
Because that committee has already gone.
Yes, your lordship.
So the committee of the base school can only.
Be
take
implemented.
this honorable-
Yes, your lordship.
That is the only.
Issue, yes, sir. He has only filed written objection on his own behalf.
Yes, lordships, the IA, that is for interim order, it may be.
No, your lordship.
Fixed
On the
process.
last occasion when the matter was substantially heard, the honorable court has particularly observed that if we decide the interlocutory application for vacation of the stay, which has been granted in favor against the respondents, your lordship, that would be deciding the final issue. So there is no point in adjudicating the interlocutory application.
Lordships, we are for 3 years. We are
No,
discharging
no.
our duties without any pay, lordships. And there is no ground.
Your
If we
lordship, I'll
go to the
satisfy your
merit-
lordship, but the order which has to be complied with is in regards with order dated 9/5/2024, your lordship, for the implement. After that process, the school management committee has to be implemented, and only after that a report has to be submitted by their council, your lordship. After that. your
SMC already replied.
No,
That
it
is,
hasn't. Only on that
headmaster is
particular
the, headmaster
occasion.
is the secretary of the SMC. And already resolution already been filed.
Okay, let us implement the school management committee.
Yes, your
Thereafter, we
lordship.
will hear you.
Yes, your lordship.
Heard Mr.
D.S. Dekha, your lordship.
Learned counsel for the applicant and Mr. Jesse Pandit, learned counsel for the respondent number. You go for respondent number?
6 and 7. SC Pandit for 6 and
6 and
7.
7 and Mr.
Lordship, I'm P. Nayak, preparing for respondent number 3, BTC authority.
Respondent number
3.
3. And 1 and 2. And madam? 4. Respondent number 4. This application is preferred by the applicant, Dharani Sandar Brahma, for implement of the school managing committee of number 115 of Zaripur LP School, PO Merkosi of district Baksa of BTR as party. As a respondent number 8 in the rate petition number 3867 of 2021. Mr. Dekha, learned counsel for the petitioner, submits that in order to adjudicate the matter, implement of the school committee, managing committee of the number 115 Zaripur LP School is very much necessary in this petition, and therefore Mr. Dekha is contented to allow the implement petition. On the other hand, Mr. Pandit, learned counsel for the respondent number 6 and 7, has opposed the petition. On the other hand, Mr. Zunso, learned counsel for the respondent number. Yes, madam. Any objection in implement? No. The other standing counsel for the respective respondents submits that no objection in the event of allowing this application. Having heard the submission of learned advocates of both the parties, I carefully gone to the petition and the documents placed on record, and also peruse the objection filed by Mr. Pandit, learned counsel for the respondent number 6 and 7. It appears that implement of the school managing committee of number 115 Zaripur LP School is very much necessary in order to dispose of the rate petition number so and so. Accordingly, the petition is thus allowed. The school managing committee of number so and so be implemented as respondent number 8 in the WPC number 3867 of 2021. The learned counsel for the petitioner shall file amended cost title within a week from today. We have to issue notice,
Yes, your lordship.
or any respondent will represent the school managing committee.
Your lordship, after issuance of notice.
Let notice go.
Yes, your lordship.
Notice.
Yes. He has filed an IA.
And after implement notice shall be issued to the respondent, newly implemented respondent number 8 by registered course with AD and also by usual process within 2 working days from today. Rest shall list the matter after 2 weeks.
Yes, your lordship. Your lordship, may I just submit, your lordship? It would be Zaripar, your lordship. Zaripar.
Zaripar.
Yes.
Is it correctly mentioned in the
Yes,
cost item?
yes, Zaripar, your lordship.
By disposal.
Much obliged, your lordship.
Card number 9.
May I please, your lordship?
Hmm.
Lordship, all the petitioners are having degree holders and they are TET qualified. As per advertisement dated 11/12/2013, the petitioners applied for the post of assistant teacher in lower primary school in the district of Kasar, Korimganj, etc. But they were not selected. Again, as per advertisement dated 12/2/2014, they again applied for the post of assistant teacher under Sarva Shiksha Mission Abhijan. But at that time they were not selected. Again, on as per advertisement that is 17/2/2014, they again applied for the post of assistant teacher, but at that time they were overaged. Accordingly, they filed representation before Director of Assam Irrigation Department, and their age were condoned. But they were not selected. They were not selected. Thereafter, some agreed petitioner, agreed candidate approached before this honorable court by filing to read petition. Accordingly, this honorable court directed the respondent of the authority to consider their candidature.
So is the number of the rate petitions are 6879 of 2014?
Yeah.
And the other is 1541 of 2015.
15.
Where is that order?
Order, my lord, at page at page 75. Order page 75. Revision 6/8/79/14.
The operative part of the order at page number?
At page number
Is 94?
At page 86. Last person.
Yes.
But their candidates were rejected as saying that 50% mark in ACES examination is preferred than graduate degree holder.
Then?
Graduate degree holder candidate.
Hmm.
The candidate who obtained 50% mark, they were given preference, but the candidate who were degree holder, graduate degree holder, they were not given preference.
Hmm.
But all the petitioners are graduate degree holder. In the advertise, in all of the advertise, in essentials qualification and essential qualification column, kindly see at page 28. 28 C5. Here it is C4 senior secondary or its equivalent with at least 50% mark with 2 years diploma in irrigation essential education, or 5 graduation from any UGC recognized university, irrespective of marks of 10 in graduation.
Hmm.
Again, my lord, kindly see page 52. Advertisement dated 16/7/40. Page 52. Column.
Advertisement at page number?
At page number 52. Here is essential qualification and experience. Number 4. Para. Column essential qualification and experience. 52. 50% in higher secondary or its equivalent, same, or graduate degree from UGC recognized university with TET passed. All the petitioners are TET qualified and graduate degree holder, but they are not preferred, they are not selected.
Hmm.
Again, in another advertisement,
Lordship, here I have received instruction. They have not, they didn't met the cutoff mark. Lordship, that's why their case was rejected. Lordship may allow me to file the affidavit within 1 week, Lordship. I'll file the affidavit on behalf of SSA.
You offer respondent number?
Lordship, 3 and 4, 5 and 6, Lordship.
5 and 6.
Yes.
Okay. Heard Mr. J. Ahmed.
P. Ahmed.
P. Ahmed. Learned counsel for the petitioner. And Mr. Sothore, learned counsel for the respondent number 5 and 6. And Madam Kaur,
3 and 4, Lordship.
3 and 4.
3 and 4.
1, 2, 3, and 4. Mr. Chaudhary submits that he has received instruction and he will file affidavit in opposition here in this case and press for granting him 1 week time. Prayer is allowed. This is the matter on COVID.
Okay, after vacation,
No, before vacation.
before vacation,
Kindly fix.
on 30 September.
30.
Item number 10,
Hello.
Maybe. Malad, the petitioner has been Malad working as subject teacher with effect from Malad 1/9/1997 to till date. And she is Malad aged about Malad as on date Malad 55 years. Now there is no scope for Malad any fresh recruitment. Now only limited prayer Malad in view of the Malad Upen Das case Malad, she is entitled to the Malad minimum scale of pay Malad. If that can be Malad provided Malad, that will suffice the case Malad. Lordship kindly see. Paragraph 22 only Malad. Paragraph 22 Lordship kindly see. That has been passed Malad in view of the Uma Devi case.
But can this ratio be applied in case of teacher? This is only in
Other
respect of
employees, Lordship
this
will
master
find.
role and
Other employees also Malad. Lordship will find paragraph 22.
paragraph.
22. Malad. That includes other employees.
So whether subject teachers can be placed similarly with master role workers works as volunteer workers.
That response maybe.
Yes, madam.
Lordship, here the petitioner is claiming for his regularization, Your Lordship. So he was appointed at ad hoc, Your Lordship, and later he has
Appointed as?
participate.
Appointed as
Honorary basis, Your Lordship.
honorary basis.
Yes, Your Lordship. And he was not also selected, Your Lordship.
Since 97 Malad till date Malad he's working. Malad only
We have
5 years
stated-
remains Malad.
We have stated
She-
in our
yeah.
affidavit also, Your Lordship.
So Malad, let them Malad take instruction whether the subject teacher is entitled to the minimum pay scale Malad. That may Malad bring Malad on record.
Okay, then you obtain instruction then.
Yes, with that effect Malad. In view of the Bandash case.
Heard Mr. Mandal, learned counsel for the petitioner. And also heard Ms. Teranpe, learned counsel for the respondent number.
2-4, Your Lordship.
Mr. Mandal, learned counsel for the petitioner. Drawing the attention of this court to a decision of a division bench of this court in state of Assam versus Upen Das and others reported in 2020 5 GLT 605. Specifically to the paragraph number 22 submits that the petitioner is entitled to minimum scale of pay as she has been serving as subject teacher since the year 1997. Accordingly, it is provided that Ms. Deranpi, learned counsel for the respondent number so shall obtain necessary instruction in this regard and apprise this court on next date. Please the matter on public.
After vacation on 25th October.
Can it be before vacation, my lord?
On 4th October.
Diplomacy.
Item 11 and 13. 11 to 13.
Lordship engaged counsel as board Hagori selects on another court. Lordship may pass out for time. Time being Lordship.
Other lordship can take up on some other day lordship. In one of the item, we have already filed our affidavit. After two, we have no other. Some other day lordship, today after 2 o'clock.
Day after tomorrow.
I'm referring, in item number 12, in my petition, they have not filed any affidavit. Lordship, I am appearing on item number 12. In my petition, government has not filed any affidavit, Lordship. Their affidavit is necessary.
Otherwise, issue involves the same, that appointment of Hindi teachers.
Yes,
Issue are
issues are
same.
but I have not received any copy of your affidavit.
Lordship will fix after 1 week, lordship, in the meantime. If required.
Okay. As agreed by learned advocates of both the parties, rest shall list the matter. After 1 week.
Lordship.
After 1 week.
Obliged.
Item number 14.
The matter relating to transfer of 2 GR cases pending before in the court of Lakhimpur, my lord, another is the court of Jorhat, my lord. Subject matter is same, my lord, regarding taking this petitioner before also he happens to be the director of a company, my lord. And they have taken money from the investors, my lord. And they were supposed to pay them, my lord, with interest, my lord, but that was not done, my lord. Ultimately, the matter was taken up by BIO, Bureau of Economic Affairs, Assam, my lord. And they lost their FIR, my lord. That FIR, your lordship will find at page 46. The company name is Response Real Estate Construction Private Limited, my lord. And after pro investigation, my lord, they have filed a search sheet on 3/11/2020, my lord, against the directors of this company. And allegation in the search sheet is that it is pending before the court of Judicial Magistrate First Class at Guwahati. Now, organization has been taken, someone has been issued.
So your prayer is to transfer those cases from?
One is at Jorhat, another is at North Lakhimpur, my lord.
North Lakhimpur.
So for the Jorhat case is concerned, my lord, the informant is a witness in this present case, my lord, which is pending in Guwahati, filed by BIO. His name is your lordship.
But the other witnesses are from Guwahati or no, from Jorhat?
Jorhat. But the facts remains the same, my lord. That I have taken money from the different persons, my lord, from the investors, my lord, and I was supposed to return the money, but
Maybe, but the place of occurrence is different.
But nature of transactions are same.
Maybe.
Because this case, my lord, which is BIO investigated, it pertains to basically Jorhat. The complainant also made witness. Jorhat case was made a witness in this case. His name is that you will also find that in list of witnesses in the success against Guwahati, my lord. He has been named as his name is Abdul Mujid, my lord. He's an informant in case at Jorhat, my lord. And he has been cited as a witness in this case in Guwahati also. And basically, whatever documents that has been pertaining to that case has already seized by BIO. from the custody of all the investors, and it was that your lordship will find from the list of documents that your lordship will find in page 62, Abdul Mujib, aged 58 years, he is respondent number 3 in the list of witness in BIO case. Sorry.
Yes, so who are for the respondents?
I am for the state in.
I am for the informant in the cases, 2 cases, respondent number 2 and 3. Jorhat case and Lakhimpur case.
So any objection on your part?
Since the witnesses are different in both the cases, there in Jorhat and Lakhimpur case, witnesses are different. There are many witnesses. And here in the BI case also, all the witnesses are not named in the search sheet.
Separate case in both the districts, my lord. And, my lord, if, my lord, now transferred to Guwahati, some witness may be in Jorhat and some witness may be in Shivsagar. My lord, that will be made delay in the process, my lord, trial, my lord. Otherwise, my lord, that is one of the aspects, my lord.
Except that, do you have any other grounds to object the petition, to oppose the petition? No other ground.
Only the witnesses are different.
Pardon?
Only the witnesses are different in both the cases. In 3 cases, BI case, Jorhat case, and Lakhimpur case.
Now, Lakhimpur, his prayer is from transfer the cases from Lakhimpur to Guwahati and from Jorhat to Guwahati, my lord. Witnesses are there in Lakhimpur and Jorhat. For my trial, my lord, it may cause delay in the process. My lord.
There was no progress, my lord, trial in those cases, my lord. That is the difficulty. Nothing has been done, I thought. Let's keep pending. At least we can expedite it yet. Unnecessarily, it has been kept pending, my lord.
Pending for whose fault? Your fault?
Not for my fault, my lord. No steps has been taken, my lord. That is the difficulty. I mean, attending my regularly. So, and you will also may kindly see the funding also very important because question of prejudice will come, my lord. Since the transactions are same, my lord, same sort of transactions, maybe in different places. Section 323 will come.
Maybe, but in a different place involving different persons.
Understood, but unity of the purpose is same, my lord. That the modus operandi is same, my lord. Accused persons are also same, my lord. The directors were made accused in this case, my lord. And therefore, question of prejudice will also come, my lord. If you have got acquittal or if you get convicted, it may affect the other case also. Considering the nature of the transaction. So for the convenience for the prosecution also, it is necessary that all the 3 cases should be tried together, my lord. At least there is no conflicting judgment, my lord.
There is?
No conflicting judgment, my lord. That is that another issue, my lord. Since the modus operandi is same, my lord. And
Okay, we'll examine the matter.
it's up to your lordship, my lord. Because it's up to your lordship. But state has, I cannot make comments because it would be convenient for the state to prosecute me, my lord. If they got all of the witnesses, because all the documents have been seized in this case, my lord. Because lordship is a BI case, all the documents, my lord. Right from the whatever documents which were made available with us, my lord, they have been seized, my lord.
Okay, heard Mr. Potoke, learned counsel for the petitioner, and Mr. Borua, learned counsel for the respondent number 2 and 3. And Mr. Parasar, learned additional PP for the respondent number 1. Argument concluded, order is there.
Just I'd like to rely on decision of Najib Singh, my lord. Your lordship may kindly take.
Submit.
Yes.
Item 15.
323, my lord. Join the all charges.
Item 15.
May it please, my lord.
This is a transfer petition for transferring of a guardianship case which is pending before the Dhemaji court to be transferred to the family court, Guwahati, my lord. May I take my lord through the petition, my lord, if it pleases my lord.
Whether notice was issued to the other side.
Notice was issued, my lord. Thereafter, my lord, dusty service was also done upon them, my lord. My lord, would kindly peruse the previous orders passed by this honorable court, my lord. They had refused to take the dusty affidavit. In fact. Upon refusal, this honorable court had fixed this matter for admission. My lord, it has been more than 1 year, my lord. They have not appeared. They have got the notice and everything. They have not appeared.
Where is the affidavit of dusty service?
My lord, may kindly have page 43 onwards, my lord, running page 43. Since my lord, they had refused, I had to take the Gao Buddha, one Shri. I'm taking my lord.
Okay, okay. Pardon me, sir.
PR Sarma.
PR Sarma, Learned Counsel for the petitioner. This application under section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring
My lord, Miss Guardianship case.
ZR case number 07 of 2022 under section 9 within bracket 1 of the Guardianship and Wars Act 1890, read section 6A of the Hindu Minority and Guardianship Act 1956, which is pending before the Court of Learned Districts as Dhemaji to the Principal Judge Family Court at Guwahati. So who instituted the suit there?
My lord,
The
my husband-
respondent.
My lord, yes, the respondent.
Now, with whom the minor is living?
My lord, my husband. My lord, my husband. That is the respondent. My lord, the problem in this case is that this case, the guardianship case was instituted in May 22. Then in October 22, my husband told me, till then my son was with me. In October 22, my husband told me that you come to Dhemaji, we will settle our disputes. When I went there with my son, my lord, he illegally kept my son. Moreover, my lord, he is having a illicit relationship with another woman and also has a child with that woman. Now my child is being exposed to such an environment, my lord. That is my problem, my lord.
No, you argued that aspect before the
Yes, my lord.
concerned court.
Yes, yes.
Mr. Sarma, Learned Counsel for the petitioner, submits that the petitioner is the wife of the respondent, and their marriage was solemnized on 8/12/2011, and out of their wedlock a male child was born to them, and his present age is 8 years 2 months. Mr. Sarma further submits that the present petitioner is presently residing at Guwahati, and the child was also living with her, but the respondent had instituted one Miss guardianship case number 7 of 2022 under section 9(1) of the Guardianship and Wars Act related section 6A of the Hindu Minority and Guardianship Act 1956 before the Court of Learned District Judge Dhemaji. And since the present petitioner is residing in Guwahati, it is not possible on her part to contest the aforesaid suit before the court at Dhemaji, and therefore it is contented to transfer the same to the family court, Principal Judge Family Court at Guwahati. Mr. Sharma further submits that after institution of the aforementioned proceeding before the Court of District Judge at Dhemaji, the respondent called the present petitioner with her child to Dhemaji to settle the dispute. And since then, the petitioner, the child is living with the respondent. And Mr. Sharma further submits that notice was served upon the respondent, but that attempt was made to cause service of notice upon the respondent by Dastimud, but he refused to accept the notice, and to that effect, one affidavit has been filed. And the respondent has refused to accept the same and contest the present proceeding. And therefore, Mr. Sharma contented to allow this petition. Having heard the submission of Mr. Sharma, learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on the record. And taking note of all the facts and circumstances, this court is inclined to allow this petition. Miss GR case number 07 of 2022, pending before the Court of Learned District Judge Dhemaji is transferred to the Court of Learned Principal Judge Family Court number 1, Kamrup M. Guwahati. The petitioner shall obtain a certificate copy of this order and place the same before the Learned District Judge Dhemaji, on receipt of which the Learned District Judge Dhemaji shall transmit the record to the Court of Learned Principal Judge Family Court number 1 at Guwahati. In terms, however, this transfer petition is thus disregarded.
I am deeply obliged, my lord.
It will,
Item number 16.
Lordship, I will be granted further 1 week more time to obtain the instructions, Your Lordship.
Your on last occasion also it was also paid because.
For the last time, Your Lordship.
A date may be fixed before vacation, my lord. Either one
Lordship,
October or.
maybe in the coming week, first up, I have no objection. But after that, I have objection, I will not be there, my lord. Immediately after the vacation, it may be listed, my lord. Matter of 2023.
okay, after reopening of the vacation. In the meantime, she will file objection. You are appearing for respondent number?
I have filed my affidavit.
No, you are for respondent number?
I am for respondent 5 and 7, my lord. We have already filed our affidavit.
5 and 7.
Lordship.
Heard, Mr.
Yes, sir, Borwe.
Learned counsel for the petitioner. And also heard Ms. Teran P, learned counsel for the learned standing counsel for the respondent number
1, 3, and 4, Your Lordship.
1, 3, and 4. And Madam Bhuya for
Respondent 5 and 7.
learned senior counsel assisted by Ms. Wenso for respondent number 6 and 5 and 7. 5 and 7 and Mr. Aman, learned counsel for the respondent number? Six. Respondent number? Two. Ms. Teran, please submits that she has she may be granted another 1 week time to file to obtain necessary instruction. The pair is allowed for the last time. SSL lays the matter immediately after reopening of the application.
On 21st October, my lord. On 21st October, then.
Okay,
21st October.
okay.
Item number 35. Upgraded item for orders.
May it please your lordship. This is interim application is for stay of the execution of the interim judgment and decree, my lord. What happened, my lord, in this case, appeal was admitted on 12/6/2024, my lord. And in IA number 1737 of 2024, the honorable court has passed an order that 12/6/2024, this IA will be considered as and when the need arise and on receipt of any notice of execution of the judgment and decree. In this case, my lord, the decree holder filed a title execution case before the learned executing court, and the learned executing court, without issuing any notice to the judgment debtor, directly issue the warrant of possession, my lord. Your lordship may kindly see in my additional affidavit, annex page 81, my lord. 13/2/2024. Decree holder is represented. Today was fixed for hearing necessary.
Page number?
Page number 81 in my additional affidavit. Filed on, it was on record, my lord. Decree holder is represented. Today was fixed for hearing necessary order at the learned counsel for the decree holder and also peruse the judgment in title suit number 235 of 94 and title appeal number 7 of 04. On perusal, it appears the decree holder has filed the present execution case within 2 years and hence there is no need to issue notice to the judgment debtors. Hence, I deem it fit to issue warrant of possession against the judgment debtors. We came to know about the filing of execution case when the police personnel visited the suit land, my lord. Your lordship may kindly come to page is 85. Order dated 28/6/2024. Case record is put up today in view of petition number 47 of 24 filed by the decree holder, perused and also heard the learned counsel of the decree holder. On perusal, it reveals that warrant of possession was issued to the civil Najib Dhubri to give cash possession of the suit land to the decree holder, but the bailiff of the court returned back and reported that without police force, execution cannot be carried out, and also prayed for sending requisition to the superintendent of police Dhubri for police force. As also seen the report of the warrant of possession submitted by the Jar Karak, wherein it is reported that armed police force Lord Mondal and civil Najira required at the time of execution. Hence, I deem it proper to direct the decree holder to take step of requisition to the superintendent of police Dhubri asking for estimate of police cost. Accordingly, the petition is allowed. And we came to know about the only on September 1st week, my lord, when the police personnel visited the suit land, my lord. So my humble prayer is, since the appeal is admitted, so the decree which is under execution is subject is, since the appeal is admitted, Lord, on 12/6/2024, and the decree under execution is subjected before this honorable. So I praying before your lordship to stay the execution case till the disposal of the RSA, Lord.
Yes, Mr. Deccan.
My lord, in this case, I have some objection in this matter, my lord. First of all, my learned friend does have shown the order page 81, my lord. It is 13/2/2024. There is no illegality on the part of passing of this order. Perhaps my learned friend is not aware, my lord. The order 21/22. in order 21, 22, within 2 years, my lord, if the decree, the execution proceeding is initiated, my lord, they are noticed not at all necessary. Beyond 2 years, if the decretal order, then it is notice necessary. Which I love to your lordship kind attention. Order 22, order 20 on rule 22. Where notice necessary and where notice not necessary. my lord. Here in this case, my lord, the impugn order they have challenged the appellate court order. It's passed on 23rd November 2023. And order 21, rule 22, it is said that notice to the show cause against the execution in certain cases, wherein application for execution is made, number A, my lord, more than 2 years after the date of decree. Here I am, my lord. The appellate court decree passed in the year of 2023, November, my lord, and we file execution in the 2020. That means within the period of beyond beyond the 2 years, within period of 2 years. So it is clear, my lord, notice not at all necessary.
No,
My-
that's all right.
And
Even though
my submission in this matter, my
the
lord,
appeal is admitted for hearing,
my lord. First of
so
all,
is
my
it
lord,
not necessary to stay the execution?
Lord, see, in this case, my lord, to get the obtained stay order, first of all, it is the also duty of the appellant, my lord, to establish, to prima facie, it is to establish that they have some the grounds to challenging this appeal, my lord. Here in this case, if your lordship permits me, the substantial question of framed by this court, my lord, I like to do your lordship that order, my lord. In the additional affidavit, my
That
lord,
is passed in their presence, my lord.
No, my
Appeal is
lord.
admitted in their presence. Since the appeal is admitted, if the execution is not stayed,
Lordship,
my
I have
appeal
to-
would become infructuous, my lord.
Lordship, I have to grounds, my lord. If your lordship, my lord, since LCR is ready, available for this court, my lord, and though, my lord, they admittedly, my lord, they are the adherents, my lord, the persons from whom they are claiming their the possessory right, my lord, they are no more the owners of the land, my lord, and we file it status.
No, we'll not hear on the merit right now.
Then my humble submission before this court, before considering their prayer, my lord, since LCR is available, my lord, we will give assurance before this court. We will not initiate any progress in our execution process. Lordship will fix the matter, entire matter of hearing.
No.
LCR is available, my lord. By my lord, by their only intention by delaying this process, they will enjoy our land.
No,
For the
my-
last 30 years, most illegally they are possessing our land, my lord. Further delaying this matter, they have taken the intention that second it will come after 7, 10 years. No, but it absolutely will suffer great hardship, my lord, and it will also will suffer irreparable loss, my lord. So my humble submission, if you also given some for time being some protection, but my for hearing may be fixed, my lord, for entire disposal. That prayer may be considered, my lord. They most illegally for the last 30 years enjoying our land. But that admittedly the RTOs and not, and they lost the person from whom they got obtained that RTO right, my lord, they are no more the owners of the land.
Okay. Heard Ms. S. Roy, learned counsel for the petitioner, the applicant, and Mr. Deka, learned counsel for the respondent. This application under Order 41, Rule 5 of the Code of Civil Procedure is preferred by the applicants for staying execution proceeding initiated by title execution case number 02 of 2024 pending before the learned civil judge junior division number 1 Dhuburi. For execution of the judgment and decree dated 11/2/2000 passed in title suit number.
35 of 94.
When the decree was passed,
No, my lord,
judgment and
the
decree,
appellate court judgment on 23rd November 2023.
Which was after,
the trial court judgment
11 to 2000.
passed in TS number 235 of 1994, passed by the learned civil judge junior division number 1 Dhuburi, by which and the said judgment and decree was upheld by learned civil judge senior division Dhuburi by judgment and decree dated 23rd 11/2023 in title appeal number 7 of 2024. Ms. Roy, learned counsel for the applicant, submits that the applicant had preferred an appeal, regular second appeal before this court, and which has already been being RSA number 96 of 2024, and the same has already been admitted for hearing, and the record has also been called for. And in the said RSA, this application, interlocutory application was filed for staying the operation of the title operation of the
Title activation. Further proceedings of the title.
Pardon?
Further proceedings of title execution case.
further
Further proceedings of title execution case.
further proceeding of the title execution case number
2 of 2024.
2024. But this court by order dated 12/6/2024 has held that the IA will be considered as and when notice of execution of the judgment and decree will be received by the applicant.
File the additional affidavit annexing the.
Ms. Roy Learned Counsel for the petitioner applicant submits that now the applicant submits that the applicant has not received any notice, but but the applicant came to know that title execution is came to know that the learned executing court in a petition filed by the decree holder, not by the respondent stroke decree holder, has already initiated the process and without issuing any notice to the present applicant has issued warrant of position against the present applicant, and therefore Ms. Roy submits that till disposal of the RSA, the further proceeding of title execution case number 2 of 2024 may be stayed. Mr. Decca Learned Counsel for the respondent, however, vehemently opposed the application, and Mr. Decca submits that the land in question was in possession of the respondents for last 30 years. And that by filing this second RSA, regular second appeal, the matter will further be delayed, and as such, Mr. Decca contended that the entire matter may be heard on merit.
Yes.
Having heard the submission of learned advocates about the parties, I have carefully gone through the petition and the documents placed in record, and also perused the order dated 12/6/2024 passed by this court. Since the RSA has already been admitted for hearing, record received in the RSA, and the record is also received from the learned trial court as well as from the first appellate court. The matter is ready for hearing, and as such, it is decided that entire matter may be heard immediately after reopening of the vacation. Recessal leaves the matter on. And
Can it be on 29 October?
Till next date. Further proceeding of title execution case number so stands state. In terms of this, next date.
In main case also, for the listing of this matter hearing below, this order clause.
In main case also, you break down. Both the parties are represented by their engaged counsel. Record reveals that LCR has already been received from the learned courts below, and the matter is ready for hearing, and as such, recessal leaves the matter on
29 October.
29. Item number 17 for orders. For admission.
Lordship, this is an executory appeal, Lordship. The insured vehicle driver did not have valid driving license, Lordship. We had examined DT also. We are held liable, Lordship. And on quantum also, Lordship, higher multiplier is used and teacher perspective also, Lordship, in higher side. These are the grounds of appeal.
This driving license was issued by
DTO Mon Lord,
DTO?
Mon, Nagaland.
And on what basis you were submitting that the driving license is false?
It was in the name of some other person, not the insured driver.
First, Mr. Azir Soikia, learned counsel for the appellant. In this appeal, under section 173 of the MD Act, the appellant, New India Assurance Company Limited, has challenged the correctness of the judgment and award dated 1/6/2024 passed by the learned member MSCT come additional district judge FTC Dibrugarh in MSC case number 11 of 2016. It is to be noted here that by in judgment and award dated so and so, the learned member MSCT come additional district judge Dibrugarh, FTC Dibrugarh has directed the appellant to pay a sum of rupees 33 lakhs
95,300.
33 lakhs 95,320 to the respondents with 6% interest from the date of filing the claim petition, that is 24/2016. Where is the memo of appeal and the grounds mentioned therein? Admit, let notice be issued to the respondents, returnable in 4 weeks, step be taken by registered post with AD and also by usual process which may come today. Call for the record from the learned member MSCT Dibrugarh, list the matter after 4 weeks. IAU deposit 50% of the awarded amount within 2 weeks before the raise day of this track.
Item 18,
Can it be made 3 weeks lordship, deposit lordship? Statutory
Why?
50%.
Why?
It may take some time.
Within a period of 3 weeks from today. Yes, Mr. Bhattacharya.
It is for enhancement. I take your lordship to directly to the page number 24. The last part, my lord, the claimant has CW1.
Page number
24. It is for enhancement, my lord.
Yes.
The claimant CW1 has stated that he suffered from the disability and he exhibited the disability certificate as exhibit number 6. In his cross-examination, CW1 has stated that 3 doctors examined his disability, but 1 doctor signed the certificate. CW1 has failed to explain why the other 2 doctors did not sign the certificate. In that sense, the CW is not considered. My lord, this disabled certificate is given by the board. My lord, it is a public document, my lord. Whether the Supreme Court says the public document need not be proved also, my lord. That is one of my ground here. So this is the case, my lord, where there is a ground for assigning this judgment, my lord. Because 35% was permanent injury. So at this stage, my lord, this appeal may be admitted, lordship will call for the record.
Heard Mr. K. Bhattacharya, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 is directed against the judgment and award dated 14/5/2024 passed by the learned member MSCT Sonitpur and MSC case number 16 of 2021, which indicate injury, filed under section 166 of the MB Act. It is to be noted here that by the interim judgment and award dated so the learned member MSCT Sonitpur in MSC case number 16 of 2021 has directed the respondent number 3 to pay a sum of rupees 79,896 rupees being the compensation to the present appellant. Mr. Bhattacharya, learned counsel for the appellant submits that this appeal is preferred for enhancement of the awarded amount. And taking this court through the judgment of the learned member MSCT, especially page number 24, Mr. Bhattacharya submits that the claimant has exhibited the disability certificate as Exhibit 6, but the learned member has not considered the same. Be that as it may, at this instance, admit the appeal, issue notice to the respondents, returnable in 4 weeks, step be taken by registered post with ADM, also by usual process. We can have it from today. Registrar will call for the record from the learned member, MSCT dashboard. It's the matter after 4 weeks.
Obliged.
The scan copies are received, my lord. And from the scan records were called for, my lord, the last occasion, my lord. And the records have been received, my lord. And from the records, my lord, it can be seen that the charges were framed on 23/12/2021, my lord.
23/12/2021,
my lord. And thereafter, my lord, against this petitioner, my lord.
21.
Yes, my lord. And against this petitioner, my lord, the case was split up on 13/9/2022, my lord. And the first witness was examined on, my lord, 8/5/2023.
Pardon?
One witness, my lord.
8/5?
8/5/2023, my lord.
Only one witness.
No, my lord, two witnesses, my lord. And the second was on 5/1/2024, the FSL, my lord. 5/1/2024, my lord.
How many witnesses cited in the search sheet?
9, my lord.
9.
9, my lord.
Out of 9, 2 have been examined.
Yes. 2 have been examined.
So whether you have been implicated by
No, my lord, these two
witness-
witnesses not implicated. Because one is the FSL, my lord, the second one is the FSL, and one was an independent witness who was standing there, my lord, Panin Nazari, but he did not implicate him, my lord. Team member, one of the team member of.
Yes, sir, Mr. Kyle.
Not, sir. And my lord, I am behind the bars for 3 years, my lord, as on date 3 years.
Yes, on the other day you have stated.
Yes, ma'am. Yes,
3 years, 34 days, and now it will be little more.
3 years, 54 days, my lord.
54 days.
Yes, sir. I'm obliged.
Here total quantity was 236.29 kgs. These were recovered from the position of the petitioner and one.
Okay,
okay,
one minute. Mr. Tiwari.
Yes, my lord.
So the quantity of contraband substances recovered from your position is of commercial quantity.
That's correct.
So you have to satisfy the requirement of section 37 of the NDPS Act.
That is why, my lord, I showed the concurrent order of the concurrent bench of this honorable court, my lord. That is, my lord, bail application of 556, my lord. There also, my lord, the quantity was around, my lord. And I being the, my lord, the handyman of the truck, I'm not the owner, because they themselves in the season have shown Manish Kumar as the driver and the other fellow as the owner of the truck. I'll show from that, my lord. And in that case, my lord, internal page 4, my lord, would see the seized ganja was 215 kg, my lord. Internal page 4, my lord, bail application number 556.
Which judgment you have relied upon?
My lord, the bail application number 556, my lord. On the other day, I gave, my lord, 4 of the judgments. That was
Bail application number?
556, my lord. Internal page 4, my lord. There are 11, my lord. Third line.
215 kg of ganja is commercial quantity and therefore the embargo of section 37 of the NDPS is applicable in this case. And accordingly, he has vehemently opposed the grant of bail to the present petitioner. Now, para 12, my lord. I have considered the submission made by the Land Council of both the side as well as the perused the materials available on record, including scanned copy of so and so. Honorable Supreme Court of India in so and so, reported in so and so, has observed that grant of bail on the ground of undue delay in trial cannot be said to be fettered by section 37 of the NDPS Act 19. And that, for that, my lord, I have shown the other judgments also, my lord. 343 also, my lord. Bail application number 343, 2024. Then, my lord, I have placed the Shaffiul judgment, my lord. Shaffiul, my lord. Shaffiul Islam, my lord. That also says, in that also, my lord, the quantity was, my lord. There, quantity was not. But in this. In Ravi Prakash, but my lord, the quantity is mentioned, my lord. In Ravi Prakash, the quantity was, my lord. 247 kg of ganja. In Ravi Prakash, my lord, the Supreme Court has noted down the 247. So the Supreme Court is clear on that part that delaying trial, my lord. It was 3 years, 54 days, my lord. By the time trial should have been completed, my lord. Now, my lord, only 2 witnesses examined, my lord. And another 7 to be examined. And my lord, one of the co-accused has already been granted bail, my lord. Manish Kumar Singh, the driver of the truck, my lord, by the learned court below itself, my lord. As per Caesar list, your lordship would find the Caesar list. I'll just take your lordship to the Caesar list for follow.
What is the trial court order?
5/11/2022, my lord. In the learned court below orders, my lord, this records, my lord, the order is at 5/11/2022 in the scan copy. One of the co-accused has been granted bail, my lord.
5/11/2022,
my lord. On medical ground, he was granted bail, my lord.
Then?
Medical ground. But, my lord, I'll take your lordship to the Caesar list for a moment, my lord. I'll just show, my lord.
You have enclosed it with your application?
Yes, my lord. Caesar list I have enclosed.
Page number?
My lord, I'll just take your lordship to page. Page 11 is the first Caesar list, my lord. The type copy, my lord. Down, my lord, the name and address Manish Kumar Singh, who has been granted bail, my lord, who was the driver, my lord. Down next page, my lord, I'll take your lordship. Page 14, relevant part, my lord. Serial number 4, page 14, my lord. 01 DL. Driving license of Manish Kumar Singh, my lord. Now, 1 and 2 are of the present petitioner, my lord, PAN card and Aadhaar card only. Then, my lord, the truck is there. This petitioner was only an handyman. That aspect they haven't denied that. But they are saying that since the contraband has been seized from the truck, my lord, and a secret chamber was made inside that. And after crashing that secret chamber, my lord, those 23 packets were taken out. And that cannot be attributed to the handyman, my lord.
Pardon?
That cannot be attributed to an handyman, my lord. Because, my lord, these handymans are very lower state of people's, my lord. They are not getting as the salary of a driver also, my lord. And as per Caesar,
But the fact remains that the articles are usually put by the handyman in the.
My lord, page 11 will show the permit and the carrier Gautam Rai, who is the owner, has been arrested from the truck itself. The owner also. Page 11, my lord.
Okay, Mr. Kyle?
Lordship. Lordship, page 13. Management of soft. Yeah. original copy, Lordship below, Manish Kumar, Gautam Rai and Syed Sani.
Manish Kumar?
Manish Kumar Singh, Gautam Rai and Syed Sani.
Hmm.
From their position, the contravent was seized. Then Lordship, may come to page 27.
Hmm. This is the final complaint.
Yes, final complaint. Accused one is Gautam Rai. Three is Manish Kumar Singh. Lordship initially was arrested, but he jumped the bail. Thereafter, non-bailable warrant was issued against him, against Manish Kumar. And he was granted bail on purely on medical ground. Lordship, secondly, on 3 occasions, witnesses present, but the counsel for the urgent petitioner was not there. On 1/3/24 also, PW was present, but he could not be examined. Then in order it is reflected that one witness was present in the court, but as because there was a opening ceremony of the court building, the court didn't examine. And therefore, on 2 occasions, the learned court was not there. The court was on leave. Lordship, I am relying on 2 judgments of passed by your Lordship and one by Honorable Supreme Court, the recent judgment. Paragraph 5, 6, 7 and 8. Yes, 5, 6 and 7. Paragraph. Yes, 2024 legal results, SC, page 6, which page 6. Sixteen, 7, 24.
Any other point?
Lordship.
And on the other day, my lord has referred to one of the judgments of my lord Pranay Sethi. Thereafter also one of the judgment of the Supreme Court has come, which is also 5-judge bench, my lord. Recent Supreme Court thereafter, my lord. Reported in 2024 SCC page 1, which says that the coordinate bench of the court order should be followed by the other court also. In referring those parts, my lord, of the Pranay Sethi and other, my lord, the court discussed about judgment in per incuriam because the earlier was not brought to the notice of the court, my lord, those aspects have been taken care of. But other way around also, the Supreme Court was very clear that if the concurrent bench of the Honorable Court passes an order in relation to a particular case, the
No,
ratio of
is
that
it,
case can be taken by the.
is it applicable in bail application?
No, my lord. That I'm not saying, that I'm not saying.
No,
I cannot
no,
say so, my
you
lord.
have to
I cannot say-
clarify it,
I cannot
whether
say
it
so,
will
my
be
lord.
applicable
No, I
in
cannot
case
say-
of bail.
No, that's purely a discretionary power. Lordship has to see the case record, that's purely a discretionary power of the Honorable Court. On that, I'm not, I'm just placing that judgment also, my lord, which was subsequently passed after, my lord, Pranay Sekhi, my lord. Para 23, my lord.
But even then,
Yes.
this Pranay Sethi is earlier in point of time.
Yes, madam. And in this case, my Pranay Sekhi has been referred, my lord, Para 23 internal page. I'll just. My lord, internal page 11, my lord. This is referred, my lord. Thereafter, other judgments have also been referred by the Supreme Court, my lord.
Heard Mr. A. Tiwari, learned counsel for the accused, and Mr. Kyle, learned counsel for the respondent. Argument concluded, order reserved.
Deeply obliged, Lordship. Deeply obliged, Lordship.
Matter number 20 by VC Mode.
Record exam.
20, my lord.
May please lordship. May please lordship.
Yes.
B Sharma is there, my lord. He's coming just, my lord, in another court, my lord.
Pardon?
For wildlife, my lord, B Sharma is there, 20.
B. Sharma.
B Sharma, he's in another court, my lord. He's just coming, my lord. He'll be taken after 5 minutes or 10 minutes.
Okay, after some time.
Item 21.
I'm being mostly, my single letter number.
Right.
21.
Case,
21. 21. My lord, this is the second time bail application, my lord. And in this case, my humble submission, my lord, I am the driver appointed by the Gothic Intensive Private Limited. And have been working under a company, my lord. The owner of the truck is Santosh Kumar Mahato, who was, my lord, granted bail by a lordship, my lord. And today, my lord, 1 year, 8 months, and 1 year, 9 months have been elapsed, even the copy is not served. So my submission, my lord, kindly see, this is the, my lord, kindly see page 31, 34, and 39. This is the service contract, my lord. Under this contract, I have been appointed by the.
Mr. Sodhore, on the at the time of hearing of the earlier bail application, you have submitted to that effect, and we have considered the same. Now you tell me on what ground you have preferred this second application.
Preferred, my lord, till date, my lord, no PW exam.
No?
Trial has not proceeded. Today is 1 year, 9 months. Even the copy has not served.
What are the how many accused are seated?
Two accused.
Two.
One is in bail, my lord.
Why the copy is yet to be served upon you?
My lord, we are appearing, my lord. But I don't know whether it is the lacuna of the trial, my lord, the prosecution.
Mr. Poraswar?
My lord, yes, my lord, I have gone through the case there, my lord, LCA, my lord. Charge sheet file on 30th of June 23. There are total 8 witnesses. But it is still fixed on, my lord, earlier fixed on 13/9 for copies. Again, last order I have flag mark, my lord. Last order dated 13/9/24, fixed on 6/11/24 for copies. Copy not yet submitted. Earlier, my lord, yes, only all dates are, my lord, on video conferencing, all and my lord, physically is present. But earlier, my lord, one granted regarding his on 1 or 2 days maybe absent, but otherwise, my lord, this is the and
few pages, my lord, I have trademark, my lord, there, last order. As per this status report, it was fixed on 13/9, but subsequent to that 13/9 order, I have trademark, my lord. Fixed on 6/11/24. Why copy cannot be supplied, that is mentioned. In 13/9.
So the next date was fixed on 13/9/2024. Whether you have been furnished copy on that day?
No, my lord. There is another order, I have trademark in the, my lord. Last date, fixed on, my lord, 6/11/24 now again, my lord. On 13/9/24.
So the case is pending for furnishing copies since 16/7/2024. Mhm. What is the reason?
That is not mentioned, my lord. I don't know, my lord. That is not mentioned in the order also, my lord. 2-3 days gone, my lord, without providing.
Only the FIR, the seizure list,
You know, all the.
and the search sheet, and the statement of how many witnesses cited in the search sheet? Eight. Statement of 8 witnesses. Nothing else.
Have been in a voluminous in another thing, my lord. There is no voluminous, my lord. Should be, my lord. Here is. Copy may be given in one day, my lord. Can be given in one day, photocopy.
Okay, we'll pass the order. Any other point?
Point, my lord, there are generally my saying, my lord, in Loricram cases also, coordinate bench pass the urban on the same footing. So whether I am the employee of a boutique industry private limited, and I have been under a service contract. Whatever I have done, my lord, pursuant to this contract, my lord, and everything is written on the contract.
Oh,
So
but
my lord,
the fact remains that the contraband substances were recovered from the vehicle driven by you.
this is right, my lord. But the vehicle is the material which has been loaded in the vehicle is being controlled by the company. This is not my, I have no any access to the materials, whatever loaded and unloaded. My duty is to drive the vehicle, nothing else, my lord. And I am not the owner of the vehicle. Owner before your lordship was also granted paid on this. And my service to drive the vehicle and nothing else. Everything controlled by the company limited. This is an, it's a company incorporated under the company's act, my lord. So I am the employee of the company. So whether in this footing should I remain in jail for 1 year, 9 months, my lord? If I say on this footing, then I can say my lord is a clear case of acquittals. So whether this, the 37 does not attract in my case. My submission is that because everything on record, my lord. Everything is on record.
So
Service
how
con-
many accused have been certified?
2 accused. Two.
Only 2.
I am the driver and another is the owner of the vehicle. Owner was granted by your lordship.
And both are appearing regularly.
Regularly. And I am in jail, my lord. I have been appearing through process, my lord. So, my lord, in this footing, my lord, should I remain in jail, my lord, 1 year, 9 months? Everything is on record.
Okay, we will see.
In any condition, my lord, I will appear if your lordship granted bail, my lord. In any
That's all
condition.
right, but this
One thing is the yes,
the article recovered from your position is commercial quantity. You
That
have to
possession, my lord,
satisfy
of the
that.
vehicle, my lord. That vehicle is, no, I'm not the owner and not, vehicle is not controlled by
Oh,
me.
maybe, but you are the driver of the vehicle.
That
from
may be a
where
process of
it
the
was recovered.
transporting the drugs. That may be a process. In the name of a company, if this it can go. Then
Clause 18,
can-
clause 19 and clause 33 of the service contract. It is also written that if anything found illegal proceeding, that may be my lord regulated by the company itself. That is clause 18, 19 is there. If I face any type of legal infirmities or legal proceeding. So should I
Clause
be my lord?
18?
Clause 18 and 19 and 33. Page 34. Whereas first pilot may read the clause 17, page 34. The company undertakes to deal with the consignor for the problems arising out of the improper documentation in relation to the shipment cargo loaded in the vehicle. If the vendor vehicle is detained due to the improper documentation of the shipment cargo loaded in the vehicle, it is the duty of the vendor to inform the company immediately without delay to enable them to arrange the release of the vehicle. However, if vendor vehicle is detained due to non-production of necessary documents to the authority pertaining to the vehicle, in that case, it will be the duty of the vendor to release the vehicle forthwith, and the losses, if any, suffered on the account shall be covered by the company from the vendor. The company will provide all documents required, ITC paper, tax invoice, UA, debit pertaining to the consignment loaded to the driver of the vehicle. On completion of exporting vehicle, however, the documents given are not produced by the driver of the vendor to the inspecting authority on demand at any place and do, the vendor will be held responsible for consequent losses, fitness penalties, etc. On that account, on default of the same, the company will deduct disproportionate amounts as notified from time to time by the company, either through circulars or through internet, from the amounts due to payable to such a vendor and will result in termination of the agreement. Number 20, the vendor hereby declares and confirms that he was personally verified the driving license and driver issued by the company authority as it is genuineness, correctness, validity and completeness, and shall further ensure that his driver shall hold a valid and authentic driving license at all times during the company consignment. Now, my lord, kindly see page 33, my lord. Page 39, my lord. 33 surplus ton. Page 39. The company handovers all the requisite documents to the driver at the booking point while starting the trip, and the driver shall hand over all such documents at the designation at the end of the trip. The vendor shall be liable for all losses and damages suffered or sustained by the company caused due to any misplacement of documents by the driver during transit.
Maybe, but this service, this agreement does not provide any immunity to you for carrying these contraband substances.
This contract, my lord, my submission, my lord, whatever loaded, there is, I have no any access to the loading and unloading. My lord. The truck is being controlled by the Gatik Industry Private Limited. Maybe something done by the some other employees, my lord, who were engaged for loading and unloading. My duty is only to drive the vehicle. This is here, my lord, clause 33, sub clause 11 also, my lord.
Sir, just one line I am adding.
This is also written, my lord, kindly see.
No, we'll say, we'll examine.
If the consignment is loaded in and sealed, and in the destination only that has to be opened. Now may see the FIR, my lord, the truck lock was found unlocked. Then where is the guarantee, my lord? He may in the middle of the road, my lord, he may this total 8 numbers of cartons are found, cough syrup found. The lock is in unlocked condition. Then it is not sealed. In the after going from the destination, he may in the road, my lord, maybe. So only saying that he is only the driver, that has to come, that has to be examined by all the
Okay.
My submission, my lord, under that.
And the FIR itself, it is
That's
unlocked condition.
suspicious, my lord, this critical circumstances. Should I be in jail for 1 year 9 months? Already passed.
Use quantity of Madam 22.
In my, to my information that my client's mother's has not yet been operated, so but I leave it to your lordship, any order may pass by you.
Pardon?
He has not yet operated, the operation was not yet done. So my lord, I won't pray anything more, my lord, before your lordship, your lordship may pass the appropriate order.
Only interim order was given, my lord,
For operation.
for operation of
Operation,
his
he
mother.
could not do it because of the financial constraint, he said. So I leave it to you, because your lordship has given enough scope to get the operation done.
And
No, what is the stage of investigation?
investigation is started, not yet filed, my lord, but there are materials, my lord, he himself, my lord, his statement, my lord. I'm reading 2-3 lines, my lord. He is a driver, my lord. সিহঁতৰ লগত চুৰিৰ প্লেনিং বনাও আৰু ফেক নাম্বাৰ প্লেট ফেক লাইচেন্স আনি মাল উঠাই পেলাই 900 বেগ দালি আৰু 400 মান বেগ লৈ পেলাই মানে all the other person also there, মানে some fake registration number, fake number plate, fake RC and license were put in before that we are transporting these goods. He is the driver. All are fake, man. And in statement, though in 161, he stated that for this, the actual owner is not responsible. I have made this all this plan with the help of some other persons, man. So he is the mastermind, man. Only he is the driver, but he is the mastermind. He is planning. So only interim was granted on because of the mother's illness and operation, man. There are materials.
Part Mr.
AB is not interim.
S.C. Biswas, learned counsel for the applicant, and Mr. Porter, sir, learned additional people for the state respondent. This pair number 2, 3, 2, 3, 2 and 3. Mr. Biswas, learned counsel for the applicant submits that this court by order dated 9/8/2024 was pleased to grant interim protection to the applicant so as to enable him to get his mother operated, who is suffering from polycystitis. And that due to some financial constraint, he could not get the operation done, and therefore Mr. Biswas submits that necessary order may be passed. On the other hand, Mr. Porter, learned additional PP has produced the case diary before this court. And submits that
22 lakh.
the IO has collected sufficient incriminating materials against the applicant, and his custodial interrogation is necessary, and therefore Mr. Porter has opposed the petition. Having heard the submission of learned advocates about the parties, I have carefully gone through the petition, and the documents placed on record, and also perused the case diary. with the assistance of Mr. Biswas. No, Mr. Parasur, learned additional PP. It appears from the order dated 9/8/2024 that only for the purpose of getting the mother of the applicant operated, interim protection was granted to him.
Rajendra Nayak.
For a period of
1 month.
for a period of 1 month. The period of 1 month has already elapsed. And according to Mr. Biswas, the applicant could not get the operation of his mother done. On the other hand, the case that he produced by Mr. Parasur indicates that investigation is still going on and there is sufficient incriminating materials against the applicant. And as such, it cannot be said that the custodial interrogation of the applicant is not required in the interest of investigation. Having considered the submission of learned advocates of both sides and also considering the facts and circumstances on the record, as well as the nature and gravity of the offense and the punishment prescribed for the same, this court is of the view that the privilege of prior's bail cannot be extended to the applicant, and accordingly the petition stands dismissed. Interim order passed earlier stands recalled. Case will be returned.
Item number 20 by VC Mode, kindly matter.
Yes.
Met also. This is the third bail application, my lord, before the honorable court, and the petitioner is in custody. Petitioners are in custody, my lord, since 5/3/2023, my lord, and now the almost they have completed more than 1.5 years, my lord, in the custody, my lord. At the same time, my lord, as per the direction of the honorable court earlier, the trial should be expedited, but the trial is not yet completed at the same time, and more so, my lord, the present petitioner number 1, his minor daughter is having some complication after post operation because she was operated heart surgery in the before he was arrested in the year 2023, my lord, earlier. So now, because of the situation in Manipur, Lordship also knows very well about the turmoil situation in Manipur.
Have you
Now, because
any medical document in support of the same?
yes, my lord, I have medical document, means discharge certificate I have, my lord. Discharge certificate I have, my lord. It is there in the election, my lord.
Page number?
46.
Page number, ma'am. Yes, ma'am. Yes, Puravi, just indicate the page. Election, Puravi. My lord, page 46, my lord. Page 46 is the discharge certificate, my lord. From the Sky Hospital, because she discharged from the hospital, my lord, on 19/1/23, my lord, just before the arrest of his father, my lord. And by the time actually she was only 10 years old, my lord, and she's having certain post complications after operation, my lord, but it cannot be now treated properly because his father is now in custody, my lord. Because of the reason, my lord, he cannot be.
Where is the document to support such averment?
My lord, only discharge certificate I have, because I mentioned, my lord, in my PAN number.
Prior to his arrest.
Yes, my lord. And now, my lord, complication is there, my lord. Averments I have taken, my lord, in PAN number.
No, that's all right. But to support the averment, where is the medical document that?
Medical document, my lord. The problem is that, my lord, she now cannot be examined further because of the, financial problem, my lord, because hardship faced by the family. That is what.
Then,
That is
what
the
basis
reason,
you
my
were
lord.
submitting that complication has developed?
Complication, my lord, because My lord, I specifically, I have
There must
specific.
be some medical document or opinion of doctor that she has developed complicacy.
No, my lord, I'm submitting, my lord, because para number 14, my lord. Para number 14, my lord, I'm just
So
taken, I have
that's all
taken.
right.
the
There
affirmance,
is
my lord.
averment in your petition, but where is the document? to
Documents,
support such
documents, my lord, because now, because of the financial crisis, my lord, she cannot go because Sky Hospital is a private hospital, my lord. She cannot go to that hospital for further treatment, my lord. That is the problem, my lord. Otherwise, my lord, she could go there, but the thing is, lordship, because of the arrest of his parent, her parent, that is petitioner number 1 in the custody, my lord. She cannot she cannot be examined further, my lord, to the hospital, my lord, since it is a private hospital, my lord. Other well-equipped hospital, because are not there in the
No,
for the government, my lord.
maybe that hospital is in Imphal.
Yes,
But
Imphal.
in your locality, there is no hospital, government hospital.
The hospital, private hospital, because, my lord, other government hospitals, my lord, are not well equipped, my lord, where she can be examined, my lord. That is the problem, my lord. At the same time, my lord, because of the ethnic class, my lord, in Manipur, now people, the peoples are suffering like anything. At the same time, the parents are also scattering here and there, my lord, when residing in the, under the rehabilitation camp, my lord. So parents are also scattering here and there, my lord. Sometimes, my lord, because of the, situation, my lord, now facing by the, circumstances, my lord. So at the same time, my lord, the offense which has been committed with this 51B is also not comes under the purview of the that I have taken a specific ground, my lord, in para number C, my lord. Their offense report dated 5/3/23, the concerned to themselves had admitted that these animals does not come under the purview schedule of the Wildlife Act 1972. Therefore, the question of applicability section 51B of the Wildlife Protection Act does not arise at all, man. And as such, there is no iota of evidence against the petitioner's, my lord. So in this case, my lord, I am submitting. There are 2 judgments, my lord, that will be supplied by my junior, my lord, who is there, my lord. And the para number, there is 1 judgment, my lord, Manish Sisodiya's case, and another is Jalaluddin, my lord. In the Jalaluddin's case, my lord, Jalaluddin's case, my lord, para number 21, my lord. And in Manish Sisodiya's case, my lord, para number 54, my lord. May I read the judgment, my lord, para number 21 in the Jalaluddin's matter, my lord. May I read, my lord, para number 21 of the judgment, my lord, which my junior will supply, my lord. Before we part with the judgment, we must mention here that the special court and the high court did not consider the material in the charge sheet objectively. Perhaps the focus was more on the activities of the PFI, and therefore the appellant's case could not be properly appreciated. When a case is made out for grant of bail, the court should not have any hesitation in granting bail. The allegations of the prosecution may be very serious, but the duty of the courts is to consider the case for the grant of bail in accordance with law. Bail is the rule and jail is an exception. Is a settled law. Even in a case like the present case where there are stringent conditions for the grant of bail in the relevant statutes, the same rule holds good, with only modification that the bail can be granted if the conditions in the statute are satisfied. The rule also means that once a grey case is made out for grant of bail, the court cannot decline to grant bail. If the courts start denying bail in deserving cases, it will be violation of the rights granted under Article 21 of the Constitution, my lord. This is one, my lord. And another in the Manish Sisodiya's case, my lord, pair number 54, my lord. I am reading, my lord. In the present case, the ED matter as well as CBI matter, 493 witnesses have been named. The case involves thousands of pages documents and over 1 lakh of pages digitized documents. It is thus clear that there is not even the remotest possibility of the trial being concluded in the near future. In our view, keeping the appellant behind the bar for an unlimited period of time in the hope of speedy completion of the trial would be deprived his fundamental right to liberty under Article 21 of the Constitution. As observed time and again, the prolonged incarceration before being pronounced guilty of an offence should not be permitted to become punishment without trial, my lord. This is in Manish Sisodiya's case. And one, my lord, I am supplying through my junior regarding the Arvind Kejriwal's case, my lord, Delhi CM's case, my lord. In the Arvind Kejriwal's case, also same thing, my lord. That has been
That is
considered.
already settled law. But the question is,
Yes, my lord.
at what stage the trial is pending now?
Trial is in the Karbi Anglong, my lord. It is not yet completed, my lord. In spite of the direction given by the honorable court,
How
my lord,
many,
on
how many witnesses have been examined till date?
my lord, to be very frank, my lord, I don't have idea regarding
My
the
lord, out of
witnesses
eight,
examination, my lord.
7 examined, my lord, and the next set is, my lord, 25/9. From this.
Out of
And
eight
that way, my lord,
witnesses, seven
Seven,
examined.
7, my lord, exam. Sorry.
So even then, my lord, yes, my lord. Even then, my lord, the denying the bail, my lord, pendency of the trial, my lord, that may not be the ground, my lord, because in the deserving cases, my lord, this case can be considered, my lord, bail can be considered. After that, my lord, the trial so that they can appoint their competent counsel to conduct their cases. Otherwise, lordship, during custody, my lord, they cannot be in the liberty to in a position to engage a good counsel, my lord, for conducting their cases also. At the same time, my lord, there is a problem, my lord, to go to the Karbi Anglong side, my lord, because of from Manipur, because there is a Kuki inhabited area, my lord, where peoples are going through that area is also very difficult for us, my lord, because of the ethnic situation, my lord, violation in Manipur, my lord. So it is very difficult to cross this, I mean, Dimapur and coming from Guwahati also. And then again, we have to cross certain Kuki areas, my lord, where we cannot enter to that Karbi Anglong, I mean, site also properly, my lord. That is why even we are very much difficult to communicate with the, I mean, this thing.
Okay, we'll see. Yes, what is your submission?
So, my lord, out of 8, my lord, 7 already examined, next set is 25/9.
Whether the
my
witnesses
lord-
already examined have implicated you?
My lord,
Implicated the accused persons?
My lord, from the family
Yes.
side also to communicate with the accused certain
My lord,
details. So, my lord,
that is
yes, my
there,
lord.
my lord, the
Yes, my lord.
two log gibbons are, my lord, recovered from their position, my lord, in one of the one track, my lord. And my lord, your lordship order is, my lord, 25 already, all the necessary things are, my lord, discussed, my lord. And my lord, for the expected trial also, my lord, that observation is also there. So, my lord, after that, my lord, everything is there, my lord, in that order, my lord. So many, my lord,
Heard Mr. S. Bhutendra Singh, learned senior counsel, assisted by Ms.
Hazarika.
Puravi.
Learned counsel for the accused, and Mr. B. Sharma, learned additional PP for the
my lord, special people, only.
special PP wildlife. Argument concluded, order reserved.
Items for
Obliged,
hearing,
ma'am.
order 41, rule to CPC, item 23.
Ma'am, please the lordship, my lord. My lord, what is the regular second appeal, my lord? Again, judgment in decree dated 31/10/2023, title appeal number 1/22, passed by the Honorable District of Hailakand, whereby the appeal has been dismissed and upheld the judgment dated 23/2018, my lord. My lord, no, practically only one substantive question, my lord. Question of advanced question. Can you see page 3, my lord? My lord, here we have set up, the defendant has set up the defense of advanced question, my lord. Of more than 12 years, he has been pausing. Now, how, my lord? Only one issue, my lord, will I think will be sufficient to see your worship. How trial court has decided that I am not in position. I did not continue the position. My lord, your worship, that is judgments, trial court judgment. Your my lord, page 33, my lord. Then issue number 2, 3 jointly discussed. Paragraph number 11, that issue has been discussed. Only one paragraph will suffice.
Page number?
Page number 33, my lord. Running page.
30?
33, my lord. Paragraph number 11, your lordship got, my lord.
Yes.
Paragraph 11, that is the issue, my lord. But how, my lord, trial court, my lord, according to my submission, has wrongly discussed. Adverse possession is a doctrine under which a person in possession of land owned by someone else may acquire valid title to it, so long as to certain the common law requirements are met and adverse possession of possession for a sufficient period of time as defined by statute. The expression adverse possession means hostile possession which is denial of the true owner. It is it must be adequate in continuity, in publicity, and in extent to show that he was in position adverse to the real owner. PW1 deposed that he allows the defendant to reside in the suit land and house to look after his ailing mother, as PW1 posted as Rangia. PW2 corroborated his evidence of PW1. PW deposed that defendant number 1 started running his stationery shop, that is myself, my lord, stationery shop in the suit land, and contained a trade license. And when PW1 came to know about it, he gave an objection before the chairperson municipal board Hailakandi. Accordingly, the trade license of the defendant number 1 was revoked by order dated 4/11/2013. Now, Exhibit 4, my lord, that is the thing. Exhibit 4 is the order of chairperson of Hailakandi municipal board, which proved in original. The period of limitation claimed by adverse possession of 12 years. During that period, the possession of adverse possessor has to be continuous and uninterrupted. In the present of the suit, in view of Exhibit 4, it is seen that the trade license of defendant number 1 was revoked by the plaintiff, did not grant NOC to the defendant number 1 to carry on the business in the suit land. Now, my lord, how cancellation of my trade license would prove that I am not in possession, my lord. I am still in possession. But these aspects can be seen. Next paragraph, next line, my lord. Exhibit 4 also mentions that plaintiff as the original owner. Obviously, my lord, plaintiff is the original owner. As the order was passed, it was brought to the notice of the chairperson by the plaintiff by petition dated so and so. Defendant number 1's claimed that he entered the suit land 2002 and has been continuously there without interruption. However, in view of Exhibit 4, it cannot be said he is in possession for 12 years or more. But how this cancellation proves that I am not in possession? This is the discussion in respect of adverse question. That has been upheld by. How it shows by that I am not in possession by. Exhibit 4 by that. It is a trade license.
So, what is Exhibit 4?
Exhibit 4 is a trade license that I have not annexed by. The trade license by which I was running a shop that has been cancelled. I am
What is the trade license before the court? We will see.
Trade license is, yes, trade license, it is mentioned here, my lord. Trade
Mention
license.
here, but you produce it before the court. Because the suit was decided on the basis of the trade license.
Yes, on this issue, my lord.
Then
I
it ought to have been the part of this record. Okay.
The only thing.
Next week, Lord Mr. R.A. Chaudhary, Lord High Counsel for the Patala.
My name is A. Chaudhary.
A. Chaudhary. R.A. Chaudhary. No, only A. Chaudhary. A. Chaudhary, Lord High Counsel for the Appellate. This is the matter on.
And a short date can be given, my lord.
Yes,
because
next
exhibition-
Wednesday. Next Wednesday.
Next Wednesday, my lord.
So as to enable him to produce the Exhibit 4, the trade license before this court. By way of an additional affidavit.
My lord. O'Brien.
1024.
This is its second appeal under section 100 of the 53. It's required against the judgment of reversal matter. Judgment dated 16/8/2024 passed by the additional district judge number 1 Kamruk Metro Guwahati in title appeal number 14 of 2024. Here, what had happened, my lord? The appellants had filed a suit for specific performance of contract, my lord. And the total sale consideration was 24,50,000. And as per the agreement, we are to pay 10,50,000 by 31/12/2014. And in fact, we had paid the said amount only 1 day delay, my lord, on 1/1/2015. And to that effect, the plaintiff, who had examined herself as DW1, she had categorically admitted regarding payment of the amount. Subsequently, again on 5/6/2015, she had taken a sum of rupees 2 lakhs. In between, we had obtained the sale permission from the deputy commissioner on 24/2015 in the month of April, my lord. And as the defendant is out of station, my lord, she is living permanently at Bangalore. So the sale permission from the office of the GMDA was applied on 18/6/2015. So there was a gap of 2 months in between, my lord. And eventually the sale permission from GMDA was also granted by the said authority on 11/2/2016. But in the month of January 2016, we came to know that she is contemplating to sell the property to some third party, my lord. So we had to issue the notice, and eventually, since she did not reply, we had filed a suit. Trial court, on the basis of the materials available on record, my lord, and on the admission made by the defendant in her cross-examination, with the respondent herein, my lord, had decreed the suit. And in on appeal, my lord, only on the ground that within 5 months, the specified period within 5 months, we could not obtain the permission from GMDA, the judgment and decree passed by the trial court has been reversed, my lord. So we have suggested certain substantial question of law at page 21, my lord. And absolutely certain perverse findings are there. The first appellate court held that there was no explanation as to why there was 2 months delay in applying for the sale permission from GMDA. That is the only ground, my lord. Also, even the evidence, if my lord, just to see, my lord, I have the evidence of DW1. She had admitted, in fact, the appellate court also discussed in the judgment that she had admitted. So the question of time being an essence of contract, she has waived it by her conduct only. Despite that, the judgment was passed against the plaintiff, my lord. And it is a matter of fact that the GMDA permission can be applied only after grant of permission by the deputy commissioner, my lord. And press affidavits and all these things are to be executed. The first appellate court took note of the fact that she had stated in her evidence that she had signed papers regarding permission prior in point of time, but that cannot be done, my lord, because fresh affidavit has to be sworn in after grant of permission by the deputy commissioner, my lord. So our substantial question of that, we have suggested, my lord, at page 21. Perversity is the main, my lord. Let me examine it.
Pardon me, sir.
TJ Soikia, my lord. TJ Soikia.
TJ Soikia, learned counsel for the appellant. This appeal under section 100, reviewed section reviewed order 42, rule 1 of the Code of Civil Procedure is directed against the judgment and decree dated 16/8/2024, passed by the learned additional district judge number 1, Kamrup M. Guwahati, entitled appeal number 14 of 2024. It is to be noted here that by the impugn judgment and decree dated 16/8/2024, the learned additional district judge number 1, Kamrup M. Guwahati, has allowed the appeal filed by the respondent stroke defendant and thereby reversed the judgment and decree dated 38/4/2024, passed by the learned civil judge senior division number 2, Guwahati, entitled suit number 95 of 2015. Peruse the memo of appeal and the grounds mentioned therein. This second appeal is admitted on the following substantial question of law. Number 1, whether the first appellate court was justified in reversing the judgment and decree dated 38/4/2024, passed by the learned trial court in TS number 95 of 2015 on wrong appreciation of Section 16 of the Specific Relief Act 1963 and thereby arrived at a perverse finding. Number 2, whether the decision and finding of the learned first appellate court is contrary to the pleadings of the pleadings and evidence of the plaintiff in respect of their readiness and willingness to perform their part of the contract. Number 3, whether the first appellate court was justified in taking presumption of Exhibit A, that is notice under section notice dated 8/1/2016 under section 27 of the General Clauses Act, notwithstanding the fact that the original of Exhibit A was not produced. If Exhibit A was neither produced nor exhibited properly. The court may also consider framing of any other substantial question of law if deemed necessary at the time of hearing with due notice to the parties. Let notice be issued to the respondents, returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. Justice will also call for the record from the learned trial court and also from the learned first appellate court. List the matter after 4 weeks.
There are two IS matter. IA number 2876 matter. One is for injunction matter because they are contemplating to sell the property matter at a higher price. So may I pray for a status quo? So if she is in position, let them remain in here, but no third party rights.
Let notice go at this instance.
Madam,
We'll fix a sort date.
there is every possibility that because in our evidence he has stated that we are not going to sell it to you, but we sell it to some third party vendor. That is clear evidence. And in fact, as per the direction of the first appellate court, madam, they have already filed an application before the trial court for deposit of the advance amount, madam. So it is apparent that they are going to sell the property. A status quo may be directed to be maintained by both the parties. They are in possession, madam.
Pardon?
They are in possession, the respondent in possession, madam, but third party right may not be created in between, madam. Otherwise, there will be multiplicity of litigation, madam.
That's all right. Let notice go. In the meantime, if you we'll fix a sort date here.
Madam, kindly, madam, because they would get the Form 50 from the office of the trial court, madam, and eventually they may.
If they made any such venture, then you mention the matter before this court rules.
We may not be in a position to get that information, madam.
Pardon?
It will be difficult, madam, on our part to get such information, madam, regarding sale, because agreement for sale may also be executed in detail. I'm humbly pray, madam.
No, to that effect, they have to obtain permission from the authority.
Even till next day, madam, status. Madam may consider India after that, till next day.
No, we'll fix a sort date and let notice start. First, Mr. DJ Soikia, learned counsel for the applicant. This application under section under order 41, rule 5.
Well, two application IS are there. This is for
Which
stay.
section 151 of the Code of Civil Procedure.
Is for stay, madam, because at page 140 of the memo, 14 madam, in the IA also, madam. At page
For staying operation of the impugned judgment and decree dated 16/8/2024, passed by the learned additional prestigious number 1 Kamrup and Guwahati, entitled appeal number 14 of 2024. Let notice be issued to the respondents, opposite parties, returnable on every date. 2 weeks.
On 3rd October.
3rd of October. 3rd of October. step be taken by register post with AD and also by usual process. Dusty service is also permitted. Respond.
My lord, the dusty service may not be possible because he resides in Bangalore, my lord.
Pardon?
The respondent resides in Bangalore, my lord.
Okay, dusty service is right.
One more I.
This other I is for
Injunction, my lord. Order 39, rule 1 and 2.
notice.
Obliged, my lord.
Item number 25, matters for orders.
No, Mr. Soikia, if we stay operation of the impugned judgment, then what purpose will be served by the other petition, other
My
application?
lord, so far as the stay is concerned, my lord, there is an order passed by the first appellate court, my lord, regarding refund of the money, earnest money that we have paid, my lord. And they have, in fact, they have already filed an application before the trial court in this regard, seeking a direction regarding refund of money, my lord. And if that order is passed, my lord, then
No.
there will be some difficulty.
If we state the order, then state the judgment,
Then also injunction would not automatically revive, my lord, because there was in the trial court, there was an order of injunction, my lord. From the day one till the disposal, my lord. There was an order of injunction, my lord. But since there was an order of injunction in the appeal, while the judgment was done, my lord, so injunction automatically was done.
so if we stay the operation of the impugned judgment and decree, then your purpose will be served.
To some extent.
Okay. So in I number 2876, till disposal of the RSA, operation of the impugned judgment and decree passed by the learned first appellate court dated stands the state. Okay.
In the injunction application, notice may be. Obliged.
Injunction number 261.
Item 25, partner matter for orders.
May I please your lordship. This matter was partly heard on last occasion, lordship, and today is it for further hearing.
Yes.
Lordship, in this matter, what happened, your lordship, in a divorce proceeding, before the additional district judge Shivsagar, lordship, the respondent has filed one application, lordship, on 5th of July, lordship, which is in page number 34. Annexure 5, your lordship. Annexure 5. Page number 34.
So where is the impugned order being challenged in this
Impugned
reading
order,
application?
lordship, impugned order is in page number 45, lordship.
Page
45.
number 45.
Lordship, 45. In this impugned order, lordship, the honorable court, in page number, in operative part, lordship, page number 47, lordship. May I go through, lordship? Page
Yes.
number 47.
Yes.
In view of above facts and circumstances of the case, without much discussion, it is directed to the number 1 Executive Director, Assistant Manager, ONGC, Assam Asset, Nazira. Number 2 Chief General Manager, so and so, Nazira. Then Head Drilling Service, ONGC, Assam Asset, Shivsagar. To arrange to disburse 50% amount of retirement benefit of present respondent, Sri Pratim Shyam, to his wife, Srimati Deepika Shyam, at the time of disbursing the amount of retirement benefit of Pratim Shyam.
till the present petitioner cease to be the wife of the present respondent by any court of law. She shall continue to avail the medical facility of ONGCL as per their rule. Therefore, we do not pass any order in this regard. Next page, Lordship. Continue. The matter of monthly maintenance allowance of rupees 30,000 paid by present respondent, paid by the present respondent to present petitioner as per their agreement shall be considered as per law after disbursement of 50% retirement benefit to present petitioner by the concerned authority. Inform all the concerned accordingly. Petition number 473 2023 dated 5/7/23 is accordingly disposed of. This is the impugn order. Lordship. What happened, Lordship? In this impugn order, though the petitioner is
So
paying,
you are for the husband.
I'm for the husband, Lordship.
You are for the husband.
Lordship, I am
Now
regular.
now you are retired from the service.
Lordship, on 31st May
Yes.
2024, Lordship. I have
Now
paid.
what is your grievance with this order?
Grievance, Lordship, that I am paying the maintenance amount of
Hmm.
rupees 30,000 since Lordship 2017, Lordship.
Hmm.
Till then, more or less, I have paid her maintenance amount to the tune of 13 lakh, Lordship. But here in a divorce proceeding, she has suddenly came with this petition, Lordship, and paid 70% of my retirement benefit, Lordship. Anyway, by this impugn order, the Honorable Trial Court has granted her 50% of the retirement benefit, Lordship. In any way, she cannot get my retirement benefit, Lordship. This is my self-earned property, Lordship. Lordship, I am paying her maintenance amount, which is mutually agreed between the parties, Lordship. As per that agreement, I am paying regularly, Lordship, which is deducted from my salary account, Lordship, directly transferred to her account, Your Lordship, monthly. And in no way I am neglecting her, Your Lordship. I am paying regularly that maintenance amount, Lordship.
Now
See-
now your prayer is
My prayer is to interfere this impugn order by Your Lordship. And Lordship, Lordship, who was that impugn order?
pardon?
Who was that impugn order? That is my respectful submission before this honorable court. Because in any
So,
way, he
your
cannot claim my
according-
retirement benefit, Lordship.
So being the wife, if she is not entitled to your benefit earned by you, who will get the benefit?
Lordship, in a
Case is going on, but still she is your wife.
Lordship, she can, in event of any decree of divorce, Lordship, she can claim for the alimony, Lordship. That can be done by her, Lordship. Without invoking any provision of law, she has suddenly came with this petition, Your Lordship. Her apprehension that I will not pay her the maintenance after my retirement. On that ground, she came with this petition, which is already, Lordship,
Now,
stated by them,
now
Lordship.
you tell me whether the authority concerned had paid the 50% amount of your retirement benefit to her.
No, that not yet, Lordship, because that entire amount is kept by them, Lordship, as per direction of this honorable court. Entire amount is with the ONGC authority, Lordship.
Acha.
Lordship, see their affidavit of opposition, Lordship, para 8, Lordship. Para 8, where they have mentioned that lordship.
That affidavit in opposition is page number.
Page number 6, lordship. Para 8.
Page number 6.
6. Relevant portion is the last part, your lordship, in page number 7, lordship. Page number 7. Why she came with this petition, lordship, before the trial court? May I go through, lordship?
No, there's her objection petition is not available here.
Lordship? Their affidavit in opposition, lordship.
Running page number will be.
Running page number is 55, lordship. Running page number 55. Internal page, lordship, 7.
Okay.
Lordship,
Yes.
last para. There is an apprehension that he will not pay monthly pension to the respondent deponent. As a result, the respondent deponent has filed the aforesaid petition claiming 70% of the retirement benefit of the petition. That I will not pay her the monthly maintenance amount. That's why her apprehension that she should get the 70% of my retirement benefit. I am regularly paying the monthly maintenance, your lordship. Since 2017, your lordship. Without invoking any provision of lordship, she has filed this petition in a divorce proceeding.
Yes, Mr. Kamali.
Lordship, regarding the provisions of law, this petition was filed under section 151 of the CPC. Because initially there was the husband developed
Included order reserve.
probably he is also agreeable to that.
Which
On
one?
the last occasion that there then consensus that
So
the
far
50% will be retained.
so
with
far
the-
the undisputed 50%
That may
that can
be-
be released to me, lordship. If
So others-
if court thinks so, if court thinks so.
Okay.
I don't have any objection in releasing 50%. Because my prayer is
But
that
you may
My
not
prayer
have,
is
but
to my prayer is to release entire amount to me, lordship.
Would it
And
be-
I am
Not
giving
the
the
prayer. I have
undertaking
objection
to
on
pay the maintenance, lordship. To pay the maintenance, lordship.
even his intention.
I am regularly paying the maintenance, lordship. Till date, lordship, we have paid more or less 13 lakhs.
okay, we will decide the issue.
Lordship.
Regarding this medical facility, he has not giving the password. So that is why I
Oh,
cannot
that
avail
is,
it.
that
So
is
that
not
is
my
his
lookout,
intention.
lordship. That is with the ONGC
Okay,
authority.
next item.
If rule permits,
Number
ONGC
26.
will look into it, lordship. I have no objection.
Item 26.
Obliged, lordship.
May I please, Lordship? And Lordship, on the last occasion, the learned counsel for the respondent has informed that the respondent number 12 and 13 expired. And accordingly, the honorable court order grants 4 weeks time to file necessary application. However, necessary application, that is substitution does not require this case, okay? Because the estate of the respondent number 12 and 13 12 and 13 is sufficiently represented by the other defendant.
No,
Well,
as per order dated 31/3/2023, whether you have filed any application.
No, Lordship, it does not require.
Pardon?
Does not require, Lordship, because their estate is sufficiently represented by other defendant.
Okay. Yes.
Lordships, respond number 12, other legal heirs are already recorded, but in respect of respond number 13, whether he is married or not married, we are not aware of that, Lordship. I have no instruction on this, but as per earlier instruction, Lordship, legal heirs of respondent 13 are available. that are required to file a substitute petition against respondent number 13. It expired on 24/9/2022, but 12 not required.
So heard, Mr.
B. Kumar, on behalf of Mr. U. Datta.
Learned Counsel appearing on behalf of Mr.
U. Datta.
U. Datta, Learned Counsel for the appellant, and Mr.
F.U. Barbuya.
F.U. Barbuya, Learned Counsel for the respondent. The Learned
I am
Counsel,
appearing for respondent number 1 to 7 and 9 to 11.
respondent number 1 to 7 and 9 to 11.
11.
The Learned Counsel appearing on behalf of the appellant submits that by the order dated 31/3/2023, the counsel for the appellant was directed to take necessary instruction in respect of implementing the legal heirs of respondent number 12 and 13 who have already expired. Today, the Learned Counsel for the Learned Counsel appearing for the appellant submits that implement of the legal heirs of respondent number 12 and 13 are not required in as much as they have already been represented by the other respondents. That is this Mr. Bhuya, Learned Counsel for the respondent submits that though implement of the legal heirs of respondent number 12 is not required, yet implement of respondent number legal heirs of respondent number 13 is required, and as such
required to file an application, necessary application for substitution, legal heirs of respondent number 13.
and as such a direction may be issued to the Learned Counsel for the appellant to take necessary step in this regard. But having considered the submission of learned advocates of both the parties and also considering the facts and circumstances on the record, it is provided that the Learned Counsel for the Learned Counsel for the appellant shall take necessary step in respect of implement of the legal heirs of respondent number 13. However, in view of the agreement of learned advocates of both the parties, respondent number 12 maybe the name of respondent number 12 may be struck off from the array of this petition at the cost and risk of the counsel for the appellant. List the matter after 4 weeks.
I have to that old matter 2010.
On 25 October.
25 October. Of last
Item-
month.
Item 28.
As per the office note dated 13/9/2024, notice on respondent number 12 was duly served. ID card returned after due acknowledgement. And so far the other witnesses are, respondents are concerned, justice service was duly tendered, affidavit was filed, and their service was duly, my lord, accepted. So matter may be, my lord, fixed for admission hearing after vacation. And interim order may be also continued.
Third, Mr. A.K. Prokesto, Learned Senior Counsel, assisted by Mr.
Yes, sir.
Learned Counsel for the petitioner. Referring to the office note dated 13/9/2024, Mr. Prokesto submits that service has already been completed and the matter may be listed for admission hearing. Accordingly, it is provided that Regis shall list the matter for admission hearing after vacation.
Interim order is after public.
Interim order is there. Okay.
And Lordship making an observation that notice on all the respondents is complete.
Okay. In view of the office note dated so and so, service of notice upon respondents completed.
An
Interim
interim,
order passed earlier shall continue.
an interim order is allowed to continue. Okay.
Item 29.
May be pleases your lordship. I am appearing on behalf of SMT 60, your lordship. Here, your lordship, instruction is awaited, your lordship. Kindly grant us further 4 weeks' time, your
4
lordship.
weeks is too long, your lordship. On last two occasion also, your lordship.
Thereafter, your lordship, puja.
From where the
vacation-
instruction will come?
Actually, your lordship, this is regarding representation.
More than the phone, already communication has been sent, your lordship.
No, from where the instruction will come?
It will give you as a-
Secretary,
Secretary?
elementary education. Your lordship.
Respondent?
The respondent Narayan.
Where the office is, where the office is situated?
This for you. This for you. Lord.
This for. So, for instruction, you need 4 weeks time.
Yes, your lordship.
Why?
Your lordship, here, your lordship, this is the contempt matter, your lordship. So relevant records may be needed to verify, your lordship.
Needed to verify, but you have already granted sufficient time.
Then after your lordship, puja vacation.
No, before vacation, we will grant you only 1 week time. You obtain necessary instruction.
Here, your lordship, SMT 60 is appearing. your
Maybe.
lordship.
We will inform Mr. Sisri. Heard, Mr.
Yeah, me right.
Learned counsel for the petitioner and Miss P. Das. Learned counsel appearing on behalf of Mr. SMT Sisri. Learned counsel for the sole respondent. Miss Das submits that instruction is still awaited and she needs further 4 weeks time. However, Mr.
It's me right.
Learned counsel for the petitioner has vehemently opposed the same. Having taken note of the submission of the learned counsel for both the parties, it is provided that Ms. Das shall obtain necessary instruction within a period of 1 week from today and apprise this court on
27 September.
it is provided that no further chance will be granted to the
Can it be-
respondent.
Can it be on your lordship, 2 weeks after 2 weeks, your lordship,
Sorry.
Wednesday?
Sorry.
Item 30.
May I please your lordship? My lord, I am for the respondent number 8 and file the affidavit opposition, my lord, today. So the,
It's a case of, well, the second wife's drawing of pension money. I am the first wife and respondent number 8 is the second wife. And she is drawing pension on the basis of a succession certificate that was obtained. And subsequently, that has been revoked after my application. my lord. So on the basis of the succession certificate obtained fraudulently, she has been drawing pension. I have got a prayer for interim order, my lord, that pension, payment of pension to the respondent number 8, the state manager. Stop.
Have you filed any IA?
No, my lord, in the petition itself, my lord, my
You have-
prayer was there. And on the day of motion, my lord, it was ordered to be considered, my lord, on the next day.
in this case, my lord, I have already filed affidavit opposition challenging that petitioner is the stranger, not wife of the deceased. He has no any legal documents. There is document.
This is the.
Affidavit opposition I have filed, my lord. This is Feroz and side legal. I am the only legally wedded wife of the deceased. During whole life of my husband, I lived with him with 2 daughters. And I am the nominee
Already her success.
of the employment. In the service book, I am the nominee, I am the sole wife. So entire facts I have stated. Nomination is paper is there and pension matter already settled. On receipt of the succession certificate issued by the London district judge. That is properly issued. There is no illegality because he is a third party stranger. She is not a wife.
Perhaps he has no knowledge regarding revocation of suspension.
My lord, certificate already challenged, appeal is filed, because the appeal already has been, the court has been called for. So that may be this was first. Revocation certificate already challenged before the Honorable High Court. Appeal is admitted records already been received by this Honorable High Court. Petitioner is not the wife. He is still the third party. He has no illegal documents. Annexer 7, Annexer. Yes,
So you file a objection.
I have filed my matter today. Just the record is not come.
I was getting maintenance death judgment also. I have annex matter at page 17. You will also.
My affidavit may be considered first. And then I have already filed my lord. Appeal against
But
that.
no copy has been served to us.
Let the matter become by fixing another date, my lord. It would be.
Mr.
Sir, I'm
Sir, you
serving
can
the copy.
take it back.
Yes, sir.
A copy, I am serving the copy, my lord. Today. After 2 weeks, maybe fix my lord.
Or
Well-
Mr. D. Shoduri, learned counsel for the petitioner. And Mr. Your good name, please.
My lord.
Your good name, please.
B. Hussain.
B.
Bilal
Hussain.
Hussain.
Learned counsel for the respondent number.
This
Eight.
Number 8 is from number 8, my lord.
Respondent number 8.
Wife of the deceased.
So you have already granted 2 weeks time by order dated 22/4/2024.
For filing affidavit, my lord, it is filed because he was suffering from illness that filed today only.
Praying for granting him 2 weeks time. 2 weeks
2 weeks, my lord.
to file affidavit in opposition. But it appears from the order dated 22/4/2024 that he has already been granted 2 weeks time, and since the date of 22/4/2024, more than 6 months elapsed. However, considering the facts and circumstances on the record, Mr. Hussain is granted last opportunity to file affidavit in opposition. Rest is the matter. Okay. Immediately after reopening of the vacation.
We will consider my interim prayer matter in the next day.
Okay, interim pair of the
Regarding interim, I have
petitioner will be
my lord,
considered on next
my
date.
serious.
Next date.
I'm appearing for one in front.
Okay.
Much.
31.
But in this case, I am supposed to file affidavit on regarding the Dosti service of respondent number 4 and 5. 1 week time I need.
1 week. Heard Mr. M.R. Khondokar, learned counsel for the petitioner. Mr. Khondokar submits that he may be granted 1 week time to file a affidavit in respect of dusty service upon the respondents. Pair is accordingly allowed. Rest is a matter after 1 week.
I'm appearing for 1, 2, and 3.
Okay.
Item 33 and 34.
কি লিখিছে আপোনাৰ নাম হেৰি পাৰ্টি নাম নহয়
Yeah, visual only. Hello, this is IA for payment of area maintenance, interim maintenance, my lord. My lord, in this case, my lord, it is pending for since 2016, my lord. Except your lordship on once in 2021 granted an amount, my lord, at the time of admission of the case, my lord, by the husband of maintenance, my lord. Thereafter, my lord, it is about 11 lakhs today, my lord. Till it is not paid, my lord, and very badly in need of money, my lord. The wife has to undergo major operation of my lord, it's medically annexed in all the affidavits and my main petitions. The minor daughter is also.
No, you tell me this IA is for what purpose?
But my lord, the stay order is the order of the my lord, revision order is stayed by your lordship on 21 on September 2021, my lord. So my lord, it's required to be modified. On last occasion, my lord, I have the wife also filed another, my lord, criminal petition number 929 NX therein, my lord, tagged with my lord. So in this case, I have a file in IA. Then it is pointed out that your lordship is already a stage, so the stay may be modified to the extent of payment of the area, my lord, maintenance, my lord.
And whether this order was carried out?
Yes, my lord.
But K dot, but.
The 50% was deposited before the
No,
rest.
my lord, it was also something misleading was done, my lord. What happened, my lord? At that time, it was, my lord, Corona, my lord, was there, my lord. So on the first day, when your lordship ordered for that, I was there. On the day the payment was every pass filed that every payment is made. On that day, I could not appear. It was upgraded. I was waiting outside because seating was limited. And then I have found the wrong amount is given in place of 420. 4,20,000 is given only 2,50,000, 56,000 perhaps, or 46,000, my lord. That's the amount. So, my lord, at this stage, what happened, my lord? She is badly in need of kindly, my lord, turn to, my lord.
Those are also serious reasons that it was upgraded and without hearing him, those orders were passed. In fact, if your lordship peruse that order, that itself reflects that his name is there, lordship.
Correct, my lord. My friend is correct.
Those are
Then I
serious
entered,
allegations against
then
the
I
council, lordship.
when
That he has upgraded it and he has done.
when the order was passed, my lord, I was there. Correct.
And in fact, after that order, he has not filed any application. He waited for 3 years
Not
and
on
now
that,
he
my
is
lord.
filing, and now these allegations are brought.
My lord,
These are serious
what I am
allegations,
saying, my lord, the order passed, when the order was passed, I was there. When the affidavit filed the next day, the payment is deposited. Then I was waiting outside. to
This
hear.
payment was not stayed by this court. The direction of
Exactly, my
this
lord.
court
But my
was.
learned friend, exactly, my lord. But learned friend, what happened, my lord? I have filed another IA 555. In my petition, the wife has filed another for extent for my lord, enhancing the amount, my lord. In that, I have filed. My learned friend objected that no, this stay is there, so you cannot. I agree with your lordship. Till as is objected, I have filed this IA again, my lord. The 668, this one is, my lord,
No.
668, my lord.
There is no stay order. Only this court has directed that 50% of the arrear amount shall be deposited before the registry of this court.
Passed in the main petition, my lord. One order is passed in the IA 439, my lord, and one is passed in the main petition. Kindly, sir.
IA 439.
439, and one is in the main petition. My lord. Two order is passed. Kindly.
In the lordship, that I have page 24, your lordship, my kindly. Page 24.
IA 668.
Yes. Page 24, considering the submission that part possible.
Page 24. Yes.
That is a state.
According to me, my lord, interim was not stayed. Interim payment was not stayed, my lord. Interim payment was supposed to be paid, my lord. It is not stayed, my lord. But my learned friend is saying that is also stayed, so I have to file the IA, my lord. And my lord, since 2016, my lord, the matter is pending. The husband never submitted his salary statement, in spite of repeated orders by the trial court, revisional court. There are 2 orders to pay the interim, not paid, my lord. My lord, even distress warrant was issued, my lord, against him. Then he got it stayed, my lord. My lord, this order, my lord. And
Yes, on deposition of a sum of rupees 2,46,000 by way of
yes,
draft.
my lord, kindly, yes, my lord, kindly turn to page.
Thereafter the order was stayed.
My lord. Kindly turn to page 10 of my lord IA, my lord, new IA, my lord. The 6668. 668, my lord.
Hmm. Paragraph number?
Which is actually listed today, paragraph 9, my lord, page 10. That in spite of orders for payment of interim maintenance by the learned trial court dated 7/1/17, my lord, and orders by the revisional court dated 22/3/18, the respondent husband did not pay the interim maintenance except amount of rupees 14,000 on one occasion only, and another amount of rupees 246,000 by order dated so and so in criminal petition number 235, this one, my lord, instant one, was paid as a precondition for admission of the criminal petition number so and so. Though this honorable court directed to pay 50% of the deed and area maintenance, which stood at rupees 4,20,000. But unfortunately, here also the respondent husband deposited rupees 246 only. The original case numbers 228/2016 filed on 24/8/2016 and payment for maintenance order to be paid from the date of filing of the application in the learned trial court. Thus, 14,000 from the month of September 2016 to September 2021. Your lordship's order, my lord. I am mentioning the month, my lord. That is 61 months. 61 months into 14,000.
There are many IAs and many criminal petitions.
Lordship,
My
just,
lord, two
may-
criminal petitions, so some other IAs, my lord.
may I
And
submit one thing, Lordship, if my learned friend agrees. Here, Lordship, there are some disputed question of facts are there. He has stated 14 instead of 12 because session judge order is in force that that has reduced. So I am not going into all those things. Instead of that, Lordship may fix it in the next next week, any date for hearing. If he withdraws this application, Lordship, I am ready to argue the case finally.
my lord, on
If
that,
if he argues on merit in this case, then Lordship, I have to brought on record all those discrepancies.
my
Because
lord,
that order was, initial order was of 14,000, which was modified by the learned session judge. Now he is calculating the entire amount which was granted by the learned CGM. So all those things I have to bring on record, Lordship. So instead of that, I am praying before Lordship that next week, any date Lordship may fix for final disposal
My
of
lord,
the case.
on
Because
that, I
your
have-
Lordship, as per your Lordship's order, both parties have already submitted their affidavit regarding assets and liabilities, Lordship.
my lord, on that point, my lord,
So Lordship may hardly
I had some submission.
Now, if the wife is in need of money, you pay some of the amount.
That Lordship, I have, as per as my learned friend probably will agree. Even my senior has already called the counsel, or called my client, and he for last chance he has asked for 3 days, as I have informed him already.
My lord, I am coming
That,
to the
he-
point, my
he-
lord.
he's-
What happened, my lord? This honorable court listed twice for early hearing the matter because considering the my learned friend submission like this, my lord. Thereafter, it was repeatedly listed and hearing for long, but never reached, my lord. Then I have mentioned again before the honorable court, the see, I am suffering so and so. My lord, this seriously in need of, critically in need of money. I will show the medical documents to your lordship. Critically in need of money, my lord. She may die, my lord. It's the situation, my lord.
Mr.
Well,
Ahmed,
what
pay
happened
some
then,
of
my
the
lord?
amount.
Lordship, we have already informed, as my learned friend will probably agree that my senior is also taking initiative to pay some amount. But if he is not, Lordship, coming up, we cannot do anything. If your Lordship give me 1 week time, or your Lordship fixes the matter for final hearing, in the meantime, I will also tell him to pay some amount.
No, you arrange some of the amount. Make payment to
We
her.
have already informed.
My lord, he has sufficient
Yeah.
means to pay,
Yeah, okay.
sufficient means to say. And my lord, one more thing, kindly note, my lord, he has filed an affidavit which of HSN liability, direct violation of this honorable court order, Supreme Court
Okay,
judgment,
okay.
my lord, and it may be called a suppression affidavit, my lord. My lord, can't
So,
we turn to
Mr. Ahmed, we'll grant you 1 week time. You pay some of the amount to her.
my lord, it is
and
11 lakhs, my
thereafter,
lord. It is 11 lakhs, my lord. Kindly, my lord.
11
Condition
lakhs.
is
Your
very
Lordship
critical, my lord.
calculate from 12,000 from learned session.
Even
judge
if my
order.
friend is correct, it may
no,
less
that's
1
all
lakh
right.
a month.
Even then, some amounts are pending now. You have to pay the amount.
That I understand. Lordship.
You make payment some of the amount. Then inform this court by way of an affidavit. Heard Mr. Talukdar, learned counsel for the applicant, and Mr. Ahmed, learned counsel for the respondent. Recessal is the matter after 1 week. On that day, an effort will be made to hear the entire matter. And
Well,
to
11
dispose
lakhs,
of
my
the
lord,
same.
as of now,
And
my
in
lord.
the meantime, Mr. Ahmed, learned counsel for the respondent, shall pay a reasonable amount to the applicant in order to arrange medical treatment of the applicant.
I'm for response number 2 in both the cases.
My lord,
For response number 2 in, I'm appealing in both the.
government, my lord. My lord, kindly 1 minute, my lord. What happened, my lord? Even, my lord, he is trying to suppress the entire amount. He has 3 lakhs per month amount. He is showing only 66,000, even contradicting his own record. So, my lord, he will, if your lordship do not fix an amount, my lord, he will come with a very poor option offer, my lord. I'm sure. This is the, my lord, this is the background of the person, so far the documents are concerned. Kindly may it be fixed to an amount. Otherwise, my lord,
that
he will come with a
aspect,
very,
then I
very
have to
poor.
pray that these matters may be remanded to trial court for leading
My
evidences.
lord, I do not know. what
If he submits in that manner, because
Even
I am
though, my
also
lord,
trying
intent
to
we
help
made,
him, Lordship.
even though
It
intent
is
we
not a
made,
case that I am not trying to help.
my lord, Supreme Court in this judgment before your lordship is, I have given there, my
No,
lord.
no, Mr. Talukdar, we will hear you finally. In the meantime, Mr. Ahmed, pay some amount to
Lordship,
her.
we have already.
My lord, kindly, a date may be fixed. Otherwise, my lord, very difficult to get it listed.
After vacation.
My lord,
Before vacation.
1 week, my lord, after your lordship said 1 week, within 1 week to, my lord, to make payment, my lord.
27th?
My lord, within 1 week, he will make payment of what, my lord?
Within 1 week?
My lord, so after that 1 week, kindly make it fix, otherwise,
No, Mr. Talukdar,
my lord.
he will not make payment.
Yes, my that is true.
His client will make
to-
payment.
Yes,
What he can do, he can suggest that make some payment.
yes, he will inform, my lord.
Except that what he can do.
Correct, my lord, but my lord, if for some long time, my lord, kindly there, my lord, see the medical condition, my lord, medically in critical condition, my lord. In emergency, medical care is required, my lord. That's why I am asking for my lord short date.
Okay.
On 27th September. Just 7 days. only.
How much?
26. Item 26.
Mr. Bhatta says that this is for releasing the amount.
No, my lord, this is for the first time it has come. There is a
Yes,
delay
it
of
is a
22 days.
condonation petition.
Yes,
What, sir?
delay of 22 days filing the
Your
application.
lordship, I am appearing for 3, 4 and 5 claimant.
Hmm.
And my learned
I am
friend is appearing for 1 and 2.
1 and 2.
All are claimants. So far the delay of 22 days is concerned, your lordship, it can be condoned.
Condon.
We
You
have
have
no
no
objection.
objection. So what is the reason for delay?
My lord, basically, my lord, I have explained in paragraph 3, 4, the official communications, because it has to be routed through the Guwahati office to the Chennai office. That is the head office of the company.
Mr. Bhatta says that is not the ground. Supreme Court has already
No,
stated.
my lord, I'm coming, my lord.
Hmm.
No, what happened, my lord? May I read paragraph 3, my lord?
Not necessary, you briefly state it.
So there I have stated that the advocate for the engaged, no, not the engaged counsel, but the panel advocate gave the opinion, and thereafter it took time for getting the certified copy of the judgment. It was sent to the head office. Head office again.
When you have applied for certificate copy?
Yes. No, it was applied on 2/5/2024.
Hmm.
So although the judgment was passed on 9/4/2024,
Hmm.
but the advocate for the insurance company applied only on 2/5/24.
Oh, who is responsible for the same?
But we were constantly pursuing the matter, but
Pardon?
the advocate concerned, whom we have empaneled to appear before the tribunal,
Hmm.
he, because of some difficulty on his part, he could not.
Well, what kind of difficulty? You have to explain that. Because in a routine manner, we are not supposed
Yes,
to
yes.
condone the delay.
Yes. That is what being I have explained in paragraph 3, my lord. That
Where you have explained it?
the paragraph 3.
Hmm.
Take to state that the learned member MSCT 1, Guwahati passed the impugned judgment on so and so. The legal officer of the insurance company has requested the counsel appearing before the learned tribunal on representing the applicant company to apply for certified copy of the said judgment. After repeated requests,
Hmm.
the said counsel applied for the certified copy of the judgment only on 2/5/2024. And such copy was received on the same
So
day.
he was empaneled by you,
Yes,
and there is a lapse on your part. Can it be said that you have sufficiently explained it?
no, that is not, I am not the counsel. I am counsel before this honorable court.
No, that's all
They are
right.
counsel.
That empaneled lawyer is who empaneled him? You.
Yes. Yes. You means when our company has empaneled.
Yes.
He was being requested to get the certified copy. my lord.
Hmm.
So he took some time. That is
So you explain it why he could not file the application in spite of being the empaneled lawyer of your company. Explain it. What is the reason?
That's okay. Can you grant me some time? I'll get the instruction.
Merely because they have not objected it, we will not
I
admit
understand,
it.
madam, but
We will not admit it. He was supposed to explain all the. Heard Mr. Bhattacharya, learned counsel for the applicant, and Mr.
And I
Mondal,
3, 4, and 5.
3, 4, and 5, and Mr.
And I can look.
Learned
Or one
counsel
and
for the respondent number
One
1 and
1 and
2.
here, your lordship, I am the caveator.
Caveat.
Caveat.
Caveat. Okay.
Caveat is there.
Caveator will be heard and stands decides. This application under section 5 of the Limitation Act 1963 is referred by the applicant Solamandalam MS General Insurance Company Limited for condonation of delay of 22 days in filing MSc appeal against the judgment and award dated 29/4/2024, passed in MSc case number 499 of 2017. Passed by the learned member, Motor Accident Claim Tribunal number 1, Kamrup M. Guwahati. Mr. Bhattacharya submits that though the judgment was passed on judgment and award was passed on 9/4/2024. The MPanel Council has applied for a certified copy of the judgment and award only on 2/5/2024. And why the certified copy could not be applied in time by the MPanel Council, Mr. Bhattacharya submits that he may be granted to bring on record the same by filing an additional affidavit. Here is accordingly allowed. Graces are raised on the after 1 week.
Right. May I please your lordship? Your lordship, my name is not reflected in the cause list. So whenever
Mr. Mondal submits that his name has not been reflected in the cause list. Graces will do the needful in this regard.
Oblige.
In this matter, I had filed our Wakalatnama yesterday only. My name is also not reflected.
Next that it will come.
37.
May I please, Your Lordship? The I for condonation of delay, today is the first day. Notice may be issued, Lordship.
Heard, Mr.
A. Burwa.
A learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred for condonation of delay of 723 days in filing the connected first appeal. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List of 4 weeks.
38.
Wait, please, your lordship. My lord, pleading is complete here. Now, your lordship, I am aggrieved by the impugn order. That impugn order page number 40, my lord. Lord, the background of the case is like this, my lord. I was given charge of a high school, my lord, as in charge headmaster. So, my lord, thereafter,
Lordship, we have received a pair-wise comment, Your Lordship, so we need 2 weeks time to file our affidavit.
You are for respondent number
1, 2, and 3, Your Lordship.
1, 2, and 3. Let them file affidavit.
Lord, my humble submission before your lordship that may I pray for interim protection, my lord, that interim order may be stayed till then. Because, my lord, your lordship would be pleased to read this order. My lord, it is not a order simpliciter. Supposing, my lord, I am in charge headmaster. My charge has been taken away. But by reading this order, my lord, it is clear that some allegation has been put against me without inquiry, nothing of this sort. I am reading this, my lord. Read the report received from the Inspector of School NDC Nagaon. On the
That order is at page number
Read page number 40, my lord.
41. Yes.
My lord, I am reading. Read the report received from Inspector of School NDC Nagaon on the allegation raised against Anwar Hussain, Assistant Teacher cum Headmaster in charge of Kothalguri AU High School, Nagaon, by his letter number so dated 21/1/2023. Also read the report of hearing conducted by Deputy Director, wherein it is opined that teaching learning activities, the working environment of the school has been jeopardized. Moreover, Mr. Anwar Hussain collected money from the students in the name of examination fee beyond the purview of the existing government guidelines. Further, the transaction of the school account was made without consent of the president of the SMDC of the school, which is violation of the rule. With the above observation, it is found that Mr. Anwar Hussain, headmaster, so School, is found to be involved in misappropriation. Your Lordship, it's when allegation has been put that I am involved in misappropriation, there must be some show cause. If I am involved in misappropriation, I would have been submitted from my post, not that my charge has been taken away. In this way, my lord, it is a
No,
aspersion
you
put on me, my lord, by this order. That aspersion will hamper my future career of service also, my lord. That is why, my lord, my humble submission before your lordship, it is a order putting some aspersion on my service career, my lord. That is why, my lord, that order may be stayed. Let the file affidavit, my lord. And in the writ petition, my lord,
Mr.
read the same,
Mr. Sheikh,
my lord,
the allegation as it appears from this impugn order
my lord.
are serious in nature.
Serious in
Besides,
nature.
you were the
My lord.
in-charge headmaster.
Yes, my lord. In that case, your lordship would be pleased to see page 35. That the president alleged against me, my lord. What is the function of the president? President, there was no confidence motion
Okay,
against the president. Page
Mr.
35.
Sheikh, let her file affidavit.
My lord,
Will consider your pair after perusing the affidavit.
my lord. Interim prayer, my lord. My interim prayer may be considered.
Yes, on next date,
After filing of
let
the-
her file a affidavit.
My lord, that may be recorded.
Heard Mr. M.S. Sheikh, learned counsel for the petitioner. And also heard Ms. Kiranti, learned counsel for the respondent number 1, 2, and 3, and Mr.
W.A. Sheikh for respondent number 5.
Respondent number 5. Respondent number 5. And who is for 4? Respondent number 4?
He is private
Lordship, a
respondent.
private respondent.
He has been served, my lord.
When?
As per office note, my lord, service was complete on Nil Pavan Borua. Assistant teacher.
Acha.
Respondent number 4.
And though as per office note dated 38/8/2024, notice was served to the respondent number 5. No, respondent number
4.
Respondent number 4.
And is in 5-2. 5.
Yes, sir, you are for respondent number 5. 5. None addressed for the respondent number 4. Though one learned counsel appeared on his behalf and filed Ukalatnama. Ms. Kiranti, learned counsel for the respondent number 1, 2, and 3 submits that she has received a fair-wise comment and she will be filing Ukalatnama within a week from today. Accordingly, it is provided that rest shall list the matter after 2 weeks. Interim pair of the petitioner will be
Not after 2
considered on
weeks,
next
my
day.
lord. Parawise comment has been received, my lord. Before vacation, it may be listed, my lord.
Vacation, we have lot of matters.
My lord.
But as your
immediately after
my
reopening.
lord, as your lordship is not granting me interim relief, my lord, so that there is urgency. So before vacation, my lord.
No.
Lordship, it won't be possible because we have to send it for the meeting also, your lordship, and it has to come back again.
41.
My lord, after vacation, a date may be fixed, my lord.
Okay, I'll give it to.
Take
41.
it that from him.
Thank you, Your Lordship. Then in this case, I am praying for release of the amount of rupees 8,85,150 deposited by the applicant insurance corporation.
Mr. Goswami, any objection?
No objection.
No objection. Heard Mr. Talukdar, learned counsel for the applicant, and Mr. R. Goswami, learned counsel for the respondent, opposite party. Number,
Opposite party, Lordship. Appellant opposite party.
opposite party number 1. This application is preferred by the applicant for releasing a sum of rupees 8,85,159 rupees deposited by the appellant oblique opposite party. That is Magma HDI General Insurance Company Limited. Before the registry of this court person to order dated 31/5/2024 in IA number 1593 of 2024, arising out of MSC Appeal number 235 of 2024. Having heard the submission of learned advocates about the parties, it is provided that the registration release the amount of rupees 8,85,159 in favor of the applicant.
Applicant, Lordship. One.
Applicants. In terms of above this, IA stands at disposal.
Obliged.
Obliged.
For hearing 39.
I'm for the appellant. The last occasion they appeared. I think today and after vacation.
After vacation. Heard Mr. Ahmed, learned counsel for the appellant, none appears for the respondent on call, recessal is the matter after vacation. Immediately after reopening of the vacation. Data DDO 15 matter. Take a date from him.
Item from production list, item 1.
Thank you, Lordship. In this case, I have filed this civil division petition, Lordship, against the order dated 10/7/2024 and 28/24, Lordship, passed in money adjudication case number 4 of the 2016, Lordship, by the learned Civil Senior Division, Dhubri, Lordship. Whereby, Lordship, issued warrant of attachment of the movable properties of the petitioner, Lordship, that is District Commissioner, Lordship, of Hatsingimari, Mankasar, Lordship. And setting terms and conditions of the proclamation of sale of and fix the case today, Lordship. For or report, Lordship. And what happened, Lordship, in this case, Lordship, the respondent number 1 filed a money suit, Lordship, for recovery of, Lordship, rupees 6 lakhs, recovery of 4,76,813, Lordship. Accordingly, Lordship, the learned court bill on 28/2016, Lordship, passed the judgment and decree, Lordship. In the said money suit, Lordship, they have made party the district commissioner as defendant number 1, and 2 is, Lordship, the SDO civil, Lordship. Hatsingimari. At that time, Lordship, it is Dhubri Hatsingimari subdivision is under the Hatsingimari under Dhubri district, Lordship. Hatsingimari subdivision, Lordship. Now it is separate district, Lordship. South Salmara, Mankasar, Lordship. So what happened, Lordship, in this case, after passing the judgment and decree, the respondent number 1 filed a Lordship money execution.
So earlier, the Deputy Commissioner Dhubri was the respondent.
Lordship.
Yes.
And Deputy Commissioner Thuburi Lordship, the case is filed in the Thuburi district Lordship.
Yes.
Civil Judge Thuburi Lordship. Now Lordship, there is a two district Lordship. Thuburi
No,
and.
that's all right.
Yes,
But
Lordship.
on account of that, you cannot abdicate your responsibility.
No, Lordship, we're ready to pay Lordship, but.
Yes,
what
when?
happened- Yeah, and also what happened in this case Lordship?
But when
if
you are
one-
ready to make payment?
Make payment from the PNRD Lordship and the State Election Commission Lordship. They are the authority for making payment Lordship. After that.
So
we are-
you tell me when you are going to make payment.
Yes, Lordship, that's why Lordship, in the money suit Lordship, PNRD and.
No,
State-
madam, you
it's not-
see, this money decree cannot be stayed
Yes, Lordship. But Lordship,
unless you pay the security amount before this court.
yes, Lordship. So Lordship, as because the money is not disbursed by the authority Lordship, that's why the Deputy Commissioner could not pay the Lordship money Lordship.
Now you tell me when you are going to make payment. You have to arrange it.
Then Lordship, I have to take and then fix up on Friday Lordship, I have to take instruction Lordship from. the-
Friday.
Yes,
Friday.
yes, Lordship, today Lordship, it's not possible Lordship.
Yes, Mr. Dubey.
In the money suit also Lordship, they have filed a representation Lordship before the PNRD for making payment of that amount Lordship. So that, and the reference one is aware about this fact Lordship, that the payment should be made by the PNRD department Lordship.
Lord, if your lordship would see the cost title petition, Lord. Lord, in a revision petition, we have been added by as a respondent by a defendant, Lord, who has not raised any objection at the trial stage, Lord, nor even the execution stage. Lord, it's
No, we
not.
have filed petition Lordship
No, no.
before the.
May you see the cost title of the money suit, Lord, at page 17.
Yes, money suit, they are not made a party Lordship by the petition and by the plaintiff Lordship.
But we have no role basically, and we can't be made parties in this manner. But in execution case also, lordship says page 36.
You are appearing for respondent number?
Number 2, Lord, Secretary State Election Commission.
Secretary?
State Election Commission. Lord, on merits, what is the dispute they have raised, Lord, between the petitioner and respondent number 1, Lord. Now at the execution stage, not also, Lord, in a revision stage, Lord, we have been included, Lord. Lord, this is perhaps not permissible in law. We ought not have been made parties herein. So far as our role is concerned, we will supervise the elections, Lord. We are not the paying authorities, though it may be
PNRD,
PNRD
Concerned
and finance, Lords.
So you are for
I am for the state election.
PNRD.
It is a pen.
Ultimately, payment has to made by the finance department after approval,
Hmm.
not from the PNRD department. But in the main title suit, the money suit, my lord, as well as the execution, we are not party there.
Yes, that is the mistake Lordship. The plaintiff has
Actually,
not
suit
made
is back
them
for
party,
non-tender
Lordship.
of necessary party also.
Lord,
Yes.
that plea they
But-
ought to have
yes,
raised
yes.
at the stage of the
Trial.
suit, Lord.
Yes,
Yes,
Lordship. But
So now we can't be added, Lord. That would be a technical error, Lord.
Hmm.
My lord, we gave time
objecting,
to
we
them
are not
for,
objecting, but.
that is
thing
what we
like
are
that.
pointing out, Lord.
No, now you come to the point how the matter could be settled.
My lord, state has to file either review or appeal, my lord.
Well,
or-
they have stated in the
Yes,
petition
we
that
are
they are
denying.
going to file. My lord, after 2016, they have awakened, my lord. 8 years. But this problem we are facing in and out, my lord, when writ petitions are being entertained, Lord, even 2002 payments have not been made. Lord, your lords would kindly take note of this. No, just I am formally saying, Lord, formally.
No, that's all right. But you have to make the payment.
Yes, Lord.
And this is a money decree, and we cannot
Lord,
stay
that's true,
also
Lord, the
without.
state has a responsibility. And your lordship would see, otherwise technically, one agency of the state is making another agency of the state a party respondent herein. So the state should speak in one language. So far as I am concerned, Lord, I am an independent agency, I don't have any difficulty, but not in the legal manner, Lord.
Hmm.
Yes, Lord.
She was
So,
rightly said.
Madam, I think better you withdraw this petition and make payment of the amount.
No, Lordship, may I fix the matter on Friday, Lordship. We have to take
Friday?
it. Friday, Lordship.
Okay.
Lordship,
Ernest,
my issue is
your
short
good name?
notice, my lord.
Madam, your good name?
D.D. Burman, Lordship, additional senior government.
D.D. Burman, learned additional senior government advocate for the petitioner, and Mr. Dubey, learned counsel for the respondent number
2.
Respondent number 2, and Mr.
S. Dr.
S. Dotto, learned counsel for the respondent number
3.
Respondent number
3.
3. The learned additional senior government advocate submits that the matter may be listed on Friday so as to enable her to obtain necessary instruction. Appear is accordingly allowed. Rest is the matter on Friday.
22nd.
Obliged.
Any other?